28, 29, and 30, Lordship. In this matter, Lordship, the matter was relating to, Lordship, non-grant of pension and the area. Now, pension has been released, Lordship. The area part, there is some dispute, Lordship. So I have to take instruction from my client, Lordship. So I have taken consent of the other side, Lordship. So may I pray the matter may be taken after 2 weeks, Lordship.
Mr. A.R. Tahvildar, learned counsel appearing for the petitioner in these writ petitions, common order volume, submits that during the pendency of the writ petitions, the pension amount of the petitioners have been released, but there are some area amounts which are yet to be paid. As such, these matters be adjourned for 3 weeks so as to enable him to obtain updated instruction. Since the prayer is not opposed, same stands allowed. Let these writ petitions be listed again after 3 weeks.
Lordship. Obliged, Lordship.
May it please your lordship, I beg to pray before listing these two matters, lordship. It has been pending since long back, lordship. The matter relates to
Your prayer is allowed, but you have to follow that procedure which now we have made. You go to the joint register bench, there is a register, you write it there. When you want listing, you put it there, you will list it.
deeply obliged, lordship.
Mention is not required, but your prayer is allowed.
May it please your lordship. Lordship, with the consent of the other side, beg to mention item number 45 and 46 for adjournment, lordship. Lordship, in item number 45, the respondents were supposed to file the affidavit. However, they have not filed it, lordship. And
45 and 46.
lordship, and 47 and 48 are also tagged, lordship. 47 and 48 are tagged, lordship. 45, 46 matters pertaining to transfer, lordship.
45, 46, 47, 48, all
48,
four.
lordship, but in 45, they have not filed the affidavit, so lordship. And
Actually,
we-
why you want adjournment?
Lordship, we are having some difficulties, lordship, today, lordship. We need certain instructions are to be.
Mr. H.R. Das, learned counsel for the writ petitioner in item 45 and 46 submits that due to some personal difficulty of the arguing counsel, these matters are required to be adjourned. Since the prayer is made with the consent of the other side, same stands allowed. Let these writ petitions be listed again after 3 weeks along with item numbers 47 and 48.
Lordship, and the interim orders may be continued.
Interim orders operating in these writ petitions, if any, shall continue till the next listing.
Obliged.
Lordship, in regards to item 31 to 37, I'm with consent from the other side, I'm praying for an adjournment.
31 to 37.
Lordship,
Yes.
these are those PNRD matters, your lordship. Lordship has heard this matter. These are PNRD's matters, lordship.
Yes.
Date may be fixed, your lordship. If it is inconvenient, it is convenient to the court.
You are for the PNRD.
Lordship, on behalf of Mr. S. Datta.
Why you are seeking adjournment?
Lordship, he is out of station for some other matters before the delay.
When?
Lordship, any date convenient to this court, your lordship. Next, after 2 weeks, any date, lordship.
31 to 37 on Lekhok. A prayer for adjournment in these cases have been made on behalf of the learned standing counsel for the PNRD department, Assam, on the ground that Mr. S. Datta, learned standing counsel, is out of station. Since the prayer is made with the consent of the other side, same stands allowed. On the joint request of learned counsel for both the sides, let these writ petitions be listed again for admission hearing on the 10th of June 2025.
Obliged, Lordship.
Much obliged, lordship.
May I please, your lordship? Lord, I am praying for listing of a case, my lord, admission matter, my lord. My lord.
Prayer is allowed, but you have to follow that procedure. Yes.
May it please your lordship. Lordship, I beg to mention item number 64 of today's supplementary list.
Hmm.
Lordship, I have taken the consent of the other side, and in this matter, regarding this matter, an affidavit in opposition will be filed by us.
Item
in the
number
course-
64.
64.
That
Lordship.
is for motion.
Motion, Lordship. Supplementary motion.
Yes.
Lordship, we are filing an affidavit in opposition in this particular case. It will be filed within the course of the day.
Who is for the petitioner?
We have taken consent of the other side as well, Lordship.
Let the matter be called up. We'll
Lordship,
adjourn.
Lordship.
Yes.
May I
Much
please, your
obliged.
lordship. Lordship, I beg to mention item number 3. Lordship, in this leading advocate, Mr. P. Deva, owing to his medical emergency, he had to go to Bengaluru. Now he is coming back tomorrow. Any date convenient of this honorable
Item 3.
item 3,
On the
lordship.
prayer of learned counsel for the petitioner. This matter stands passed over for the day. List again in the next week.
May it please your lordship. Your lordship, I have to mention item number 23, your lordship. I have obtained the consent of the other side, your lordship. Due to some personal difficulties, your lordship, the matter may be passed over for the day, your lordship.
Item 43.
23, your lordship.
23. On the prayer of learned counsel for the writ petitioner made with the consent of the other side, admission hearing of this matter stands adjourned for 2 weeks, list accordingly.
Silence.
May I please your lordship? Your lordship, I beg to mention item number 5 of today's daily list. I'm paying for adjournment for 2 weeks, your lordship. A senior colleague is out of station. Or something.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks, list again for motion after 2 weeks.
All right. May I please your lordship? Lordship, I beg to mention for listing of WPC for order. Your lordship, I kindly fix the matter on 26/5.
Yes, you just enter it in the register, it will be done.
May I plead your lordship, I beg to mention item 2 for adjournment per week.
Item 2,
Yes,
motion.
yes, your lordship.
You have informed the other side.
There are no private respondents, your lordship.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for a week, list accordingly.
It pleases your lordship. Lordship, I beg to mention with regard to item number 41, lordship. One affidavit in reply have been filed yesterday, lordship. Kindly record may be called for.
Item 41,
41. Lord.
all right.
Of the-
Give a slip.
May I please your lordship? Lordship, I beg to mention for motion matter for listing.
Motion,
Motion.
when do you want it?
Got employed.
When?
Treasurer.
Yes,
Lordship, I'm making a mention on for item number 55, my lord. What has happened, my lord, we were directed to take steps to dusty service, my lord.
Hmm.
We filed the dusty service, but unfortunately we could not contact our client, my lord. So it is not completed, my lord. So may I pray that your lordship will grant an opportunity. We'll take steps to registered post, my lord, that Walpara Municipal Board, my lord.
all right, but why don't you wait when the matter reaches with us?
May I please your lordship?
Yes,
Lordship, in these matters, we need some time, lordship. We don't have any communication with the client right now, lordship. Whether to file reply or not, lordship.
what is there in this case?
Nothing, my lord. This is already covered by division bench as your lordship judgment, my lord.
Your client is not coming because
We have filed long back, we have filed affidavit.
she knows if she comes, he has to, he has to,
One date, lordship.
huh?
One date, lordship, we will communicate in between.
How much time
2
you?
weeks, lordship.
2 weeks. Yeah, Mr.
A Mena, lordship.
Mr. A. Menal and his counsel appearing for the writ petitioner submits that due to and submits that he has lost contact with his client as a result of which updated instruction could not be obtained. On such ground, the petitioner's counsel has prayed for posting this matter again after 2 weeks so as to enable him to obtain instruction. Mr. T.J. Mohantal and his senior counsel assisted by Ms. P. Sharma is present on behalf of the APSC and Mr. A. Dhar, learned Ardhar, Mr. Additional Senior Government Advocate Assam has appeared for this state. Deeply.
May I please, your lord? In this case, the standing counsel was directed to take instruction.
Yes, cure the defect.
Yes, sir.
Have you cured the defect?
Yes.
My lord, the inquiry report has been set aside and my lord, he has been allowed to cross-examine my lord, the witnesses in respect of him, of which my lord, he was denied. So now, my lord, the order has been passed to my lord, allowing him, my lord, to cross-examine, and thereafter, my lord, the inquiry officer will submit the fresh inquiry report in terms of the Assam Disciplinary Service Rules 1964, my lord. His basic grievance was that once the, my lord, inquiry is complete, an inquiry report having been submitted, subsequently you cannot allow me or direct me to cross-examine.
Already I was acquitted on 2 charges, made.
So what has happened now? Inquiry report has been set aside.
Set aside, my lord.
Who has set it aside?
My lord, the disciplinary authority.
Where is the power to do it?
My lord, the power is under the Assam Disciplinary Manual of Departmental. It is stated here, my lord. The penultimate paragraph.
Let us see.
Yes. If your lordship, my lord, allows, I'll file an affidavit, my lord.
Rule 9 says otherwise, my lord. Rule 9A, my lord.
Let him then file an affidavit.
Yes, my lord. I'll file an affidavit because here it is mentioned, my lord,
Hmm.
6.18. It says, my lord, that if the disciplinary authority finds at any stage of the inquiry that he is prejudiced, my lord,
Hmm.
the delinquent is prejudiced,
Hmm.
the inquiry report can be set aside. From the stage, my lord, where the prejudice has been caused, from that stage it can be set aside. And from that stage, my lord, the inquiry can start afresh. This power is there, my lord. I can satisfy your lordship by filing an affidavit, my lord.
Let him file the affidavit
Legally,
because we have to resolve this issue this
Yes.
way or that way.
Way that way.
Either they will go ahead or they cannot go ahead.
Go ahead, yes, but
Correct.
because rule 9 doesn't say so, my lord.
Right.
That is that.
So
again.
both ways, without an affidavit, it cannot
That
be
cannot
done.
Correct.
So should
be.
we?
Question of law, my lord.
notice?
It's very-
Huh?
My lord, it can be taken up on motion itself.
Hmm.
I'll take 1 week or 10 days time. Lordship can dispose it of.
It can be taken, my
Then
lord.
we'll have it after 2 weeks. You
My-
file your affidavit within 1 week and he'll file it, his
My
rejoinder.
lord,
within
correct.
Till then, my proceedings may not be stopped, my lord, because already.
Don't proceed with the
My
matter.
lord, there is no question of
No, I
any.
have received the notice, my lord, to appear before for cross-examination.
Yes.
This next,
When is the date fixed?
no, next date is on 25th, man.
In view of this order, whether my lord further cross-examination will take place, my lord.
But my client has received notice, my lord.
This is an order setting aside, my lord, the inquiry report.
No, but it is doubtful whether you can set aside.
Yes.
You can't
Court
set
can set
aside
aside
an
it better.
inquiry report.
Yes.
You can disagree with it. You can disagree,
Yes.
but
No,
whether you
lordship will
can-
examine that aspect
Hmm.
because departmental manual proceeding is very clear. That if the.
That's all right.
disciplinary
What happens to the proceeding? It will continue.
My lord,
Either you give an assurance or we'll stay it. There is no third option.
which one, my lord?
The proceeding.
Because I was allowed to cross, directed to appear before.
No,
inquiry.
lordship will make it clear, my lord, I will file an affidavit until your lordship resolves, my lord. It will not proceed, but my lord,
All right.
the matter is sub judice, my lord. How can we proceed, my lord? Huh? Notice
All
দিব তো
right,
আপনারা, দিলেহে আপুনি যাব,
Where is the impugn? Where is the impugn notice?
That's. Page,
You want to talk something? Both of you?
No, no.
no, page 108, man.
No, it's good to be.
Page 108.
Communication is always good.
My lord.
Lack of communication creates
My lord,
lots of
senior
problems.
friend is apprehensive, my lord, that
Hmm.
he pursuant to that notice, now he will be called, my lord, for further
Then I
cross-examination.
have received, I have to file application.
No, his apprehension is justified.
Correct, correct.
Justified.
Because-
He cannot be subjected like this unless there is a decision on this issue.
My lord,
Court has to either give a green signal and
Yes.
then only you can proceed.
yes.
So his apprehension is just. Where is the?
108, man. Annexure 16, man. Last page.
Heard Mr. P. Kodagilar, counsel for the writ petitioner. This writ petition is directed against the order dated 21/3/2025, by means of which the inquiry officer was directed to hold further inquiry so as to cure the defects in the inquiry report. According to the petitioner, such a recourse is impermissible in the eyes of law. In terms of the order passed by this court, Mr. S.K. Talukdar and his standing counsel for the Cooperation Department was granted, has obtained instruction and submits that by the notification dated 5/5/2025 issued by the Secretary to the Government of Assam Cooperation Department, the inquiry report itself has been set aside and a direction has been issued to proceed afresh with the inquiry proceeding after giving opportunity to the petitioner to cross-examine the witnesses. According to Mr. Talukdar, such a recourse is permissible under the Assam Service, what
No,
is it called?
Manual of Departmental Proceedings, my lord,
Manual of Departmental Proceedings,
more particularly paragraph 6.18,
more particularly paragraph 6.18 and
framed
therefore
under, my lord, the Assam Service Disciplinary Appeal Rules
framed
1964.
under, Service Manual framed under Assam Service Disciplinary Appeal Rules 1964. In support of his argument, full stop Dipala, he has referred to para 6.8.
6.18, my lord.
6.18 of the manual.
Yes,
Mr. Talukdar, however, prays for 10 days time to file affidavit,
Yes.
bringing the stand of the department on record. Considering the fact that the issue would require, the issue raised in the writ petition would call for adjudication by this court. Hence, the time for filing affidavit as paid for is hereby allowed. Issue notice of motion returnable on 9th of June 2025. We'll make it 13th of June. What is
Yes.
the hurry? 13th of June 2025.
My lord, if it comes for motion, then my lord, disposal may be next.
Fix it as
My
an
lord,
admission.
correct.
Since Mr. Talukdar, Learned Standing Council Cooperation Department, Assam has appeared and accepted notice for all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers be filed. May be furnished to the Learned Departmental Council so as to enable him to file affidavit. The writ petitioner may file rejoinder thereafter if so advised. Register to list this case again on 13/6/2025 for admission as a fixed item. An attempt will be made to dispose of the writ petition at the stage of admission hearing. Till then, further proceeding in connection with the the inquiry proceeding contemplated by the impugned order shall remain suspended.
Deeply observed.
That is a lawsuit. But the matter pertains to the non-payment of the salary of the present petitioner because of the non-release of the last pay slip by the Guwahati Medical College and University.
He has already resigned.
I have already given resignation, your lordship.
It is accepted.
No
Has it
any,
been accepted?
no any order has.
Then what is the relief you are seeking here?
Lordship, we are seeking the relief from the salary with effect from January 2020, 29 January 2024 to till the date of my submission of resignation, your lordship.
We'll have to issue notice at this stage.
Lordship may take-
Notice?
Lordship.
What?
Or
You
lordship
want
may
the
keep it as a
petition to be
motion or
allowed
to
today?
take instruction, your lordship.
Uh-huh.
Keep it as a motion and to take instruction where my LCP has not been
No, that is because you have not joined and you are not working. Then
I
that
have
is
I
not-
have already joined your lordship. Pursuant to the order, I have joined in the Barpeta Medical College and Hospital.
All right, let them file an affidavit.
Okay.
You have to wait for a little while. I had Mr. L. Mohan, Learned Counsel for the petitioner, peruse the amendments made in the writ petition. Being internally aggrieved due to non-payment of his salary since the month of
January 24th.
January 2025. The petitioner has approached this court.
January 24.
24 lordship.
January 24.
January 2024, the petitioner has approached this court seeking a writ of mandamus upon the respondent authority. Ms. S. Sharma, Learned Standing Counsel for the Health Department, prays for some
All the respondents.
instruction. Full stop. Issue notice of motion returnable in 4 weeks. Since Ms. Sharma has appeared and accepted notice for all the respondents. No formal notice is required to be sent in this case. Extra copies of the petition requisite in numbers be furnished to the Learned Standing Council so as to enable her to obtain the instruction and file affidavit. Since it is a question of non-payment of salary of the petitioner, this writ petition is directed to be listed again on 25th of June 2025 as a fixed item.
Lordship, so for respondent number 6, that is not required. That may be strike off.
1 to 5 corridor. On the request of Mr. Mohan, the name of the respondent number 6 is hereby struck off from the array of parties. Petitioner to accordingly file amended cost title. Bagini eke thakibo.
Thanks. May I plead your lordship? The matter pertains to non-payment of the arrear substitutions salary of the petitioner during his period of suspension, your lordship.
So here also notice has to be issued.
Yes, sir.
Heard Ms. F. Hussain, Learned Counsel appearing for the writ petitioner, peruse the amendments made in the writ petition. Full stop. The petitioner, who is serving as a lot mandal in the Dhubri Revenue Circle, was placed under suspension for certain period. Full stop. The grievance of the petitioner pertains to non-payment of arrear subsistence allowance for the period during which he was placed under suspension. Mr. J. Handing, Learned Standing Counsel for the
1 to
Revenue-
3 lordship.
Revenue Department prays for some time to obtain instruction. Issue notice returnable in 6 weeks. Since Mr. Pandik has accepted notice for respondent numbers 1 and 3, 1, 2, and 3.
1, 2, and 3.
1, 2, and 3. And Miss M. Bhattacharjee, learned additional senior government advocate Assam for response numbers 4 and 5. And Mr. P. Nayak, learned counsel for the response number 6. Service of notice is deemed to be complete in this case. Extra copies of the petition from our requisited numbers be furnished to the learned department counsel so as to enable the.
Deeply obliged, Your Lordship.
But we are challenging a cancellation of the appointment, my lord. After post appointment, my lord, he was stated to be medically unfit because of a accident that happened in 2000.
Disease actually?
My lord, he actually had met with an
Craniotomy means?
Craniotomy means, my lord, open skull surgery.
So why you have cancelled his appointment? Why?
I've seen instruction. Notice me.
You suffered an accident and you have thrown it out.
2013, my lord.
Huh?
Notice me. This is notice me. Go, madam.
What kind of approach is this? Will issue notice at this stage?
Yes, madam.
Heard Mr. B. Patel and counsel for the petitioner. Also heard Mr. S. K. Medil and CGC appearing for the respondents, being aggrieved by the cancellation of his appointment on certain medical condition arising due to an accident met by the petitioner while in service. The instant writ petition has been filed. Mr. Mary prays for some time to obtain instruction in the matter. I know I'm 6 weeks, but you can likhe dekho. All the respondents. Mr. Dekha, what case do you have?
We're seeking
2015.
true.
Then? If it is true,
we-
then
we've been,
everything else is false. You have come after how many years?
Lord, since it's, I'm seeking quo warranto, perhaps the rule of delay would also stand relaxed, my lord. And it's. If I may just point out, my lord, the page 28, if your lordship takes up for a moment.
Yes. The questioning somebody's appointment made in the year 2020, 2015, 10 years back.
True, my lord.
Quo warranto does not admit to rules of equity.
It does, my lord, but
Yeah, yeah.
ultimately, if it's an usurping of a public office, my lord, then perhaps locus, delay, all these.
Why have you kept quiet for so long?
Lord, we are just, we have been procuring all the information by securing RTIs. And there was also an inquiry conducted, but there was no action thereafter, my lord.
So this is practically this is a PIL.
It's a quo warranto, my lord.
Maybe, but you don't have any. See, rates could be anything, but you are not personally affected. You are not seeking a mandamus for yourself.
No, my lord. No.
Therefore, it is a PIL. You want the court to dispense with the rule of locus.
Which is already there for quo warrantos, my lord, if I have understood the law correctly. So, the judgments which have said, since it involves usurping of a public office, my lord, anyone from the public could come. In fact, the instances where the reverse is held, when someone has an interest, he should ideally go for a certiorari. But when it comes to quo warranto, my lord, any member of the public, perhaps.
Mr. Dekha, fundamentally, I am finding it difficult to accept your argument, and I'll tell you the reasons. You basically want the appointment of respondent number 6 to be set aside.
My lord.
Correct.
Right.
On the ground that it is illegal.
Yes.
So, if your argument is to be accepted, then every case where somebody is seeking setting aside of an order of appointment will come within the ambit of writ of quo warranto. But quo warranto, as I understand, subject to what you say, is asking the person who is occupying an office as to what authority he has to occupy that office.
Yeah.
His authority is his appointment order, respondent number 6. How can you? Respondent number 6 is occupying the office because of the appointment order.
Yes.
So what authority? This is the authority. Warranto fails today itself.
But if your lordship can examine whether it has been done totally dehorsed, well, in fact, there are illegalities, your lordship will
That
be
is a
suppressed.
question
Stop
of
the consent.
See, the ground could be something.
Alright.
Maybe the order is illegal. The order you are questioning,
Yes.
maybe it will turn out to be illegal. That I'm not even going into it.
Right.
All I'm saying is that you want the court to issue a writ of quo warranto,
That's right.
saying that under what authority are you
Yes,
occupying the
yes.
office? His answer will be the authority is my appointment order.
And that that appointment, if that appointment is totally dehors the law, then the courts can exercise this writ, my lord.
Then it will be a writ of certiorari.
But that is what the difference they've said is, if I'm an aspirant to the post itself, then it at best be a certiorari, nothing more. But if it's usurping of a public office, dehors the rules, my lord, anyone can come
Oh,
forward.
all illegal appointments then will come under quo warranto. Is it not?
My lord, they have specified which all. I'll just show from the writ petition, my lord, just what the illegality precisely
It's
is.
an illegal order.
No.
Now proceed.
No.
The order of appointment is illegal. Let's presume it. Absolutely illegal. Now proceed to convince the court that how an illegal order can be interfered under writ of quo warranto. That's what I'm asking you.
24.
You need not labor on that the order is illegal. Have you understood the query?
I have perhaps one. 24 too.
Or do you need some time to read?
No, my lord, I'll take this one. Your lordship will kindly bear with me for. Yes, Rajesh Avasti, sir. Para 16 first, if your lordship has.
Para 16.
Yes. Rajesh Avasti, 2013-15 SCC 501. Para 16, a writ of quo warranto will lie when the appointment is made contrary to the statutory provisions. This court in so-and-so versus so-and-so held that the writ of quo warranto can be issued when the appointment is contrary to the statutory provisions. In B. Srinivasa Reddy, this court has reiterated the legal position that jurisdiction of the High Court to issue a quo warranto is limited to one which can only be issued if the appointment is contrary to the statutory rules. The said position has been reiterated by this court in Haribans Lal, wherein the court has held that for issuance of a writ of quo warranto, the High Court has to satisfy that the appointment is contrary to the statutory rules. Now, if your lordship may skip over.
I'll tell you, I'll issue notice because he won't know what is happening.
Yeah.
If I ask him, he will say I get time to obtain instruction.
Alright.
But I am telling you today why this para 16 will have no relevance. If you ask the court to issue a quo warranto to call upon the respondent number 4 to satisfy,
Yes.
on what basis he is occupying that post of,
He'll show the appointment.
then that is applicable.
Yes.
But since you are questioning the appointment of respondent number 6, which order was issued by the respondent number 4,
Yes.
through a writ of quo warranto, his appointment, whether it can be interfered with, I have my doubts. So there is a difference between the two.
Alright.
Respondent number 4, yes. If you say that he was not authorized to.
Well, that's just one part of the illegal. Well, it's statutory provisions.
What is your instruction? What do you have to say? Nothing.
Only on the ground of delay. Here, after 2000, after 10 years, that's the only preliminary objection. I don't have any instruction at this point of time.
Then
Para 25 is the answer for delay.
will issue notice. You heard Mr. B.D. Dekkal and counsel for the petitioner, peruse the amendments made in the writ petition. By filing this writ petition, the petitioner is praying for issuance of a writ of mandamus oblique quo warranto, questioning the legitimacy of the appointment of respondent number 6 on the ground that the order of appointment is completely divorced the rules. Full stop. In support of his above prayer, Mr. B.D. Dekker, learned counsel for the petitioner, has placed reliance on the decision of the Supreme Court rendered in the case of Rajesh Avasti versus Nandlal Jaiswal and others, reported in
2013-15 SCC.
2013-15
SCC.
2013-15 SCC.
1 SCC, I'm sorry, 501.
2013 1 SCC 501. para 16. Mr. D. Bora, learned government advocate Assam, on the other hand, has questioned the maintainability of the writ petition on the ground of delay and latches, but he seeks some more time to complete his instruction. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Bora has appeared and accepted notice for respond numbers
1 to 4.
1 to 4. No formal notice is required to be sent to the said respondents. Extra copy of the writ petition, requisitive numbers being furnished to the learned government advocate Assam within 3 days from today. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD within a week from today. The question of maintainability of the writ petition is kept open and shall be gone into at this stage of admission hearing.
Nice.
But I'm not convinced that
I'll try.
maybe certiorari, I understand.
Yeah.
Who warrant you is you have to ask that person itself what authority you have. He has to come and satisfy the court that yes, my appointment to the particular post is legitimate. But here he will say that my appointment is as per the order of appointment issued by a competent authority. The order may be legal, illegal, that's another matter. That will be the subject matter of certiorari. So 16 is rendered in that context.
Hello.
Check it
Oh,
once
there's a
again.
24. I'll place it. Hello.
What this petition is praying for regularization of an employee in grade 4 of Assam Fishfed, my lord, who was initially engaged in the year 1995. As a grade 4 employee.
29 years not regularized, you will have to regularize. Those days are over now. You can't make people work for 30 years.
Lordship, we have taken over only in 2018, Lordship, this department.
So
So, I have to take instruction, Lordship, because
see, this is totally inhuman. You can't make people work for 30 years and say that we don't know who you are. We have to, constitutional courts cannot
yes,
ignore this.
Lordship.
So you better come up with your instruction, we'll dispose it off on the next day.
Lordship, some other matters are also pending, Lordship. I think, yes, other matter also. Let it take, Lordship. Number to have.
What other matter?
Similar matter.
No, we'll see. So each case will depend on the facts.
Lordship.
The fact of the matter is, lot many people are working for 10 years, 15 years, 20 years continuously, and they're seeking
Lordship,
regularization.
the problem with us, Lordship, Fishery Department has taken over only in 2018. Lordship.
Maybe, but the
there is
law
a-
doesn't change.
But there is a,
You do it now. You do it now. What will these people do?
Lordship, let me take instruction, Lordship, this.
If he is not regularized, he is not going to get pension, his family is not going to get any benefit. Why have you made him work for 29 years without regularizing? It is a lapse on the part of the department. It is not his fault. I'm fixing it on the next day, we'll dispose it off. You better come prepared.
Lordship.
The writ had Mr. So-and-so and counsel for the petitioner. The writ petitioner hearing is an employee working under the Assam Apex Corporation Fish Marketing and Processing Federation Limited, bracket Fish Fed. Full stop. He is being serving as a fixed pay worker in a grade 4 post. The grievance of the petitioner is that despite rendering continuous service for more than 29 years, his service has not been regularized for no valid reason. Full stop. Hence, the petitioner has approached this court by filing this writ petition. Stop. Mr. P. Sharma, understanding counsel for the corporation, please for some time to obtain instruction.
And for Fishery Department,
For the
including.
Fishery Department, please for some time to obtain instruction. Issue notice of motion. You tell me the date. We'll have it as a fixed item.
Lordship. Lordship, let it be June 11, Lordship.
Huh?
June 11.
June 11, all right. In the meantime, you process it.
Lordship. I will take.
Issue notice of motion. 11/6/2025. Since Mr. Who is appearing for whom?
I'm appearing, I'm appearing for 4, 6, 7, and 8.
Acha, who is appearing for one?
One.
appearing for one.
He is appearing.
This is Ms. Dev Sharma and its government advocate Assam has appeared and accepted notice for respondent number 1.
Who is P.
Mr.
Nayak?
P. Nayak, Lanet's additional advocate general Assam bracket finance bracket close for respondent number 2. Mr. 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 A.J. Sharma and Standing Council Corporation Department, Assam for respondent numbers 3 and 5, and Mr. P. Sharma, Land Standing Council Fisheries Department, Assam for respondent numbers 4, 6, and 6, 7, and 8. Service of notice is deemed to be complete in this case. Extra copies of the writ petition will be furnished to the learned departmental council so as to enable them to obtain instruction and file affidavit facilitating expeditious disposal of the writ petition. Registered to list this case again on 11/6/2025 as a fixed item. An attempt would be made to dispose of the writ petition at the stage of admission hearing. We'll club all these matters. The Constitutional Court will not accept this. If you are keeping people working continuously for 10 years, 15 years, you will have to regularize them. Create superannuation posts and regularize them. And you give all the numbers, we'll club it and pass an order. We are not accepting this. People are in absolute distress. Thousands of people are coming to the court. They are working for 20 years, 20 years, not only your department, other departments also.
But
Where will these people go now?
in my department also, this actually there is a cabinet.
Add one line. On the next date fixed, Mr. Sharma to also obtain instruction, written instruction and appraise this court. How many casual stroke fixed pay employees are working in the department who have rendered more than 10 years of continuous service? We produce it. We'll pass a comprehensive order. Yes.
Apply, sir.
Allowed same order, 32 years now.
Huh?
Same facts.
Same facts, 32 years. List along with.
But we will give the numbers, Lordship.
I'll not have the numbers today, my lord, but on the next day I can make a mention for the matters to be listed on 11th of June.
During the course of the day, Lordship.
Those cases you have it with you.
Yes.
See, nowadays we have a register in the bench section. You do not need to beg for listing of your case before anyone.
Yes.
I don't know why the bar is not understanding.
I understand.
You go there, you write down which case you want to be listed when. I am inspecting that register.
My lord.
They will have to list your cases. At best, it could be 2-3 days
Yes,
plus
yes,
minus.
I understand. my lord.
Why people are making mention? This is a system in your, where the power is with you.
Yes, yes, my lord.
Where,
You go and make a mention, whichever case you want.
Grateful, my lord.
highly obliged, Lordship.
Lordship, regarding this case, we'll be filing an affidavit in opposition within the course of the day.
Next week, then,
My lord.
after a week, Mr. M.R. Khandakar and counsel is present for the petitioner. On the request of Mr.
Miss A. Bora's name
Ms.
is.
A. Bora. Now let counsel appearing for the respondent numbers 2 and 6 who submits that an affidavit on behalf of the department will be filed during the course of the day by serving advance copy upon the petitioner's counsel. Let this matter be listed for motion again after a week by tagging the affidavit, if any, with the record of the case.
Much obliged, Lordship.
Obliged. My lord, may I please date, my lord?
You have not heard after 1 week. What is the date after 1 week? Check it, check it.
That it may be my lord on 2nd of June. my lord.
1 week it will come, you be there. Yes.
I am ready.
For admission, other matter, I can join.
Lordship, Mr. P. Nayak is on leg. Sometime may be allowed, Lordship.
If I can, if subject.
All right, we'll take it after the other
Fine,
matters.
fine.
May I please, your Lordship?
Yes.
Well, matter pertains to non-awarding of senior grade to the petitioners, my lord. Being a, my lord, he's a APSC cadre and my lord junior engineer under establishment of the, he is not only claiming, my lord, he has already retired. There is, my lord, regulations. And my lord, on the last occasion, my lord, an opportunity was given to file affidavit. Other side is not giving any response, my lord.
Yes,
Yes,
we
it's a
had,
2017 matter.
Lordship, we had written to the department for instructions, my
No, we
lord.
proceed and decide it.
Otherwise, my lord,
No,
when
2017, enough writing has happened. This is now 8 years? If the department has not given you instruction in 8 years, forget it. You can't compel people to wait for 8 years for an answer. All right, you are going merit. We'll take it up for disposal. Yes, what is your case?
My lord, case the petitioner is my lord, there is a my lordship may kindly charge the page 16, my lord. My lord, that
Just 1 minute. The petitioner is working as a junior engineer.
new engineer, my lord,
He was appointed in 1988.
1988, my lord.
No promotion till date.
My lord, no promotion till date.
And he is seeking senior grade
Senior
pay.
grade, my lord.
Show me from the rules how he is entitled to same.
My lord, the
Have
rules
you
is,
submitted any representation?
my lord.
Where is
submitted
it?
Representation, my lord. Lordship will file the representation, my lord, on page 18. Page 18,
Page 18.
my lord, page 18 and 19. Two representations were submitted, my lord. Some communications were made, my lord. Department has issued letters.
No, I'm asking, have you submitted any
My lord.
representation?
On 18
Where-
and 19, my lord, will find.
No, Mr. Das, this is not a proper representation.
My lord.
My prayer has been forwarded to you. That is not a representation.
My
What is your prayer? Have you told them?
My lord.
Where is that
My lord,
representation?
on 19, my lord, will find. Some description is there. And he's claiming, my lord, that his salary to be enhanced in the, my lord, payment pool. I have not been awarded. Senior grade.
Yes, and which provision of the rule says that you are entitled to it?
My lord, that rules, my lord, that copy I do not have, my lord. There is a communication, my lord. Lordship may
No,
kindly
then
conduct-
you submit a fresh representation. We'll ask the chief engineer to consider
My-
it, pass
my-
appropriate orders.
my-
All right, heard Mr.
PK
P.K. Das, learned counsel appearing for the writ petitioner, also heard Mr. This is item 13, huh? Mr. I. Bothagu, learned standing counsel for PHE department, Assam, appearing on behalf of respond numbers
2, 3, and 4, my lord.
2, 3, and 4. Miss P. Sharma, learned counsel, is present for the respond number 7, bracket APSC. Report Mr. D. Bora, learned G. Assam for respond number 1, then Bothagu 2, 3, and 4, and Miss P. Sharma for respond number 7, bracket APSC. None has appeared for respond numbers 5 and 6. Full stop. The case of the petitioner, in a nutshell, is that he was appointed as a junior engineer in the PhD department way back on 26/11/1988. Full stop. He joined service on 6/12. Accordingly, he joined service on 6/12/1988. The grievance of the petitioner is that on completion of 8 years of service, he was entitled to be designated as a senior grade junior engineer and also extended the benefit of pay scale for senior grade cadre. However, notwithstanding such entitlement under the rules, no such benefit has been given to the petitioner, although persons junior to him in the gradation list of junior engineers published on 14/9/2012, that is the respond numbers 5 and 6 hearing, have been conferred with such benefit. Full stop. The petitioner, full stop. The petitioner had submitted representation before the respond number 3, that is the chief engineer, PHE, bracket water, Assam, ventilating his grievance in the matter. However, since no action has been taken on such representation, the petitioner has been compelled to approach this court. Full stop. This writ petition was instituted in the year 2017. However, even after the lapse of nearly 8 years, no affidavit has been filed on behalf of the PHE department. Full stop. Mr. Bothakur, the standing counsel for PHE, submits that despite several communication issued to the authorities, no instruction has been received till today. Full stop. On a pointed query made by this court, Mr. Das, and counsel for the petitioner, also could not point out any provision in the rules which would permit this court to issue a writ of mandamus. Under these circumstances, the only recourse left open for this court is to direct the petitioner to submit a fresh representation before the authority for consideration of his grievance in accordance with law. As such, this writ petition is being disposed of by granting 4 weeks' time to the petitioner with effect from today to submit a fresh representation before the respond number 3 by enclosing a copy of this order ventilating his grievance in the matter. Stop. If such a representation is submitted within 4 weeks from today, the same shall be considered in accordance with law and disposed of by a speaking order within 6 weeks thereafter. Stop. Whatever be the outcome of the process, the same shall be intimated to the petitioner in writing. Stop. If the writ petitioner continues to remain aggrieved in the matter, even thereafter, it will be open for him to seek remedy before the court of law once again. With the above observation, writ petition stands disposed.
Obliged.
Lordship, Lordship, I'm praying for a short adjournment in this matter, as the day is not available.
2017 cases.
Lordship,
Why don't you try yourself? What is the matter about?
Lordship is claiming for pension, basing his whole service period.
Ah,
Staff,
claiming pension since 2017. You have not paid pension.
no, he hasn't been paid pension, Lordship.
Next Friday is a fixed
I-
item
yes.
on the request of Learned Departmental Council. So and so appear. Your name, please.
Eighth board we have.
So and so for petition on the request of Learned Departmental Council. Let this matter be listed again as a fixed item on next Monday. Na, you put it on 2nd June.
Obliged, Lordship.
If here in this matter, Lordship, Learned Additional Advocate General will appear, Lordship, in this matter. He is on legs in court 4, Lordship. Otherwise, Lordship, pleadings are complete. Lordship, can this matter be taken up on a hearing date, Lordship? Pleadings are completed, Lordship. Or after some.
Hearing that may be fixed, my lord.
3rd June. So and so for the petitioner, so and so for the respondents. And the joint request of, it is submitted the bar that pleadings are complete in this case and therefore the matter be taken up for disposal on a non-miscellaneous day. In view of the prayer made at the bar office to list this case again on 3rd June.
Highly obliged, Lordship.
3rd June, you are available
My lord, Indian that, my lord, after 7th.
after 7th. All right. 10th June, 10th of June 2000 as a fixed item. for
Highly
admission issue.
Okay, today, they have to produce the instruction that bill has been passed, lordship. Last occasion they have submitted regarding the regulation of the panchayat town committee. The last occasion, the other side, they have placed that the cabinet decision has been taken, some bill has been passed. So lordship was directed to them to produce the bill.
Yes.
Lordship. With apologize, Lordship. Here in this case, Lordship, I do admit it that it is my fault. It is my limitation, Lordship. So far, Lordship, the director, Lordship, so far all preparation was done by him, Lordship. But what happened, Lordship, he would like to take an approval from the government, Lordship. Just now, I talk with him, Lordship.
Approval from government. for
Lordship,
what?
regarding there is a question of the rules, Lordship. Because, Lordship, what happened, Lordship, earlier he prefers for the decision of the cabinet, Lordship. That was subsequently modified, Lordship. That was set aside, Lordship. And government took other decisions, Lordship. And for getting all these things, Lordship, the director has prepared his all this instruction, Lordship, for me, Lordship. But
Where is the recent bill passed by the Assam
Lordship,
State?
that's why, Lordship, already passed, Lordship, but it was for it is sent for governor's signature, Lordship. Governor asked some queries to the department, Lordship. And therefore that is pending, Lordship. And therefore, to regarding all this instruction, Lordship, the director already prepared the instruction. He told me just now, Lordship, and he sent it to the governor, Lordship. Sorry, Lordship, government, Lordship, for taking approval, Lordship. And thereafter, Lordship, he will say,
No, he has to file an affidavit by next week.
Lordship.
We don't know what is happening, what has been sent to the
Lordship,
government.
Lordship.
We are not concerned.
Lordship.
You have, the court has asked you to place that instruction.
Lordship.
It has to be placed, or
Lord-
why it has not been placed, he has to file an affidavit.
Lordship, yes.
Otherwise, we'll initiate contempt procedure.
Lordship, I will file the affidavit,
File
Lordship.
it by tomorrow.
Lordship, tomorrow it will be some.
All right, day after tomorrow.
Lordship, day after tomorrow.
On Monday, list again on Monday
Lordship.
as a fixed item, so as to enable Mr. J.K. Goswami, Learned Additional Senior Government Advocate, Assam, to file a short affidavit as regards the instructions called for by this court pertaining to the bill passed by the Assam State Legislative Assembly. It is made clear that if the affidavit is not filed, affidavit sworn by the director of
Director of Municipal Administration, Lordship.
you give it 27th, you put it
Lordship.
27th. Municipal administration is not brought on record honor before 26/5/2000 25, then this court will consider directing personal appearance of the concerned authority on the next date fixed.
Lordship,
Mr. H. Raman and senior counsel is present for the read, assisted by Mr. So-and-so. is present for
Lordship,
the read.
I will-
27th,
Lordship,
we'll have this matter.
yes.
If the affidavit is not here, he will come personally.
No, no, I
And
will,
we'll call him in the second half only,
Lordship,
not
I
another
will-
day.
Lordship.
You can't play around with a court order like
No,
this.
no, Lordship, I am fairly submitted,
Huh?
Lordship.
No, when the court says produce it, you have to produce it.
Lordship,
You
Lordship,
can't say it is gone to so-and-so and so-and-so.
Lordship,
Protocol doesn't work in court. Don't be under any misconception.
Lordship.
The protocol in a government function doesn't work in a court proceeding. Court proceeding is a serious business. You have tendered apology even on the last occasion.
Lordship,
Have you not?
Lordship.
So what do you think? You will go on tendering apology and court will
No,
agree?
Lordship, I am trying, Lordship.
No, there is nothing personal about you.
Lordship,
The departmental
these are the-
official will have to.
these are the communication, Lordship, I received, Lordship.
Mr. Goswami, the court is not saying anything to you,
Lordship,
but we are asking repeatedly, where is the instruction? We want to pass a final order.
Lordship.
He's saying it has gone here, it has gone there.
27, Lordship, I will.
Huh?
27,
So what if it has gone there? The court wants to know what has happened.
Lordship.
If a bill is passed in the assembly, is it a rocket science or a secret document? Why your officer is not able to say what has happened in that? We are not asking a copy of the bill.
Lordship.
Next,
Lordship.
27th. Then if we don't get the instruction or information, then
I will,
we'll pass some other order. Please tell him.
Lordship, here in this matter, Lordship, I have received some instruction from the DME office, Lordship. The complete instruction is yet to be received from the GMCH authority to file my affidavit. Lordship, can this matter be taken up after a week, Lordship? I'll file my affidavit by then, Lordship.
Lordship, rule issued on 19/2/2020, Lordships.
2 weeks last chance, otherwise
Lords.
their right to file affidavit will
Lords.
stand forfeited. Heard Mr. R. Sharma, learned counsel for the lead petitioner. Also heard Mr. Du Peminu, learned standing counsel, Health Department, Govt of Assam, who prays for further 2 weeks time to file affidavit. First up, the prayer has been opposed by Mr. Sharma on the ground that this matter pertains to the year 2020 and several opportunities have already been granted to the state to file affidavit. Be that as it may, considering the nature of issue involved in this proceeding, 2 weeks further time as last chance is granted to the respondents to file affidavit, failing which their right to file affidavit will stand stuck off in this case. Register to list this case again after 4 weeks as a fixed item for admission hearing.
Highly obliged. Lordship, can this matter, 18, Lordship, can this matter be taken up tomorrow, Lordship? Because, Lordship, I have received certain telephonic instruction that this matter pertains to National Health Mission, Lordship. So they have a separate set of counsel and they have not been made a party here.
Then
So
we'll
let-
have it next week.
Next week.
Fixed again on Monday. So and so by reflecting the name of Learned Standing Council NHM in the cause list.
Lordship, they have not been made a party, Lordship. So let me have that instruction, written instruction.
NHM is not a party.
They have not made a.
Standing Council will appear. If they have not made a party, they will make a party or will dismiss the writ petition.
Highly obliged.
26th, yes.
May please, your Lordship. Here in this case, petitioner's limited grievance is that he participated in a number of selection process and he is a physically handicapped candidate. And in the selection process, the government office memorandum, my lord, that there is a specific instruction that provision that the persons having benchmark disability party selected on own merit shall not be adjusted against the reserved vacancy. That guideline has been violated in the present case, my lord. That is our grievance.
He raised by the correct, we have filed affidavit. That petitioner says he has learned that he has two advertisement. And he could not secure the,
So pleadings are complete.
he has not filed affidavit. Affidavit.
Mr. Sikdar, pleadings are complete.
My lord, I am to file reply, my lord.
Then file it.
My lord.
Why are you arguing on merit? How much time you want?
My lord, 1 week time.
Mr. R. Sigdal and counsel for the writ petitioner prays for and is granted 2 weeks time to file rejoinder in response to the counter affidavit filed by the APSC authorities. Party নাম করে দিয়ে দিব। Yeah, development. List accordingly. Yes.
Last time they have filed affidavit, that is sports, the director of sports, youth affair.
Yes, what is this matter about?
Unpaid salary. And they are ex-employees of the Assam Science Club. And their salaries have been paid. Their salaries have been compliance with this court's order. They have paid the area salaries, but not in revised pay. Revised pay has not been given, and provision fund also not released.
The pay was, their salary has been paid.
Salary has been paid.
When it has been paid?
It was paid.
So this will admit and post for hearing. Will admit the writ petition. Acha, how many respondents are here?
4 respondents. 1, 2, 3, 4.
What about respondent number 1 and 3? Anybody is appearing? 3 and 5. There is no respondent number 5 here. Which item? Which is the case number?
17.
Is there a respondent number 5 here? Just have a look. Have a look. Is there an amendment in this case? Some
Not separate,
amendment of cost title?
Because the cost title was amended.
Oh, okay, okay. So have you filed amended cost title?
Yes, my lord. Long back.
I'm afraid for the department.
Okay, you are for respondent numbers? 1 and 2. And who is for 3? No, no, no. 3 is the flying club.
Flying club is represented by sports and director of sports and welfare.
Who is appearing for the respondent number 3? Has notice been served? Heard Mr. S.M. Sharma, learned counsel for the petitioner, also heard Ms. U. Sharma, learned G. Assam, appearing for respondent numbers 1 and 2, and Ms. S. Bakht, learned standing counsel for Cooperation Department, appearing on behalf of the respondent numbers 4 and 5. No, but I want to know which respondents.
Actually, in the both of our petitions, respond number 3 is registered, respond number 4 is Assam Flying Society, and respond number 5 is joint registration.
Register to verify if any counsel has appeared on behalf of the Assam Flying Club Society. And thereafter list the matter and list the matter after 3 weeks with appropriate office note. Let it first be ascertained. Otherwise, we can't dispose of the matter. He also doesn't know.
My lord, here in this case, I have filed an affidavit in reply day before yesterday. I have checked up, my lord, that is not on record. Let the matter be taken up along with my affidavit in reply.
Mr. R. Islam, counsel for the petitioner, submits that the rejoinder affidavit filed on behalf of the petitioner day before yesterday, that is, give the date, is not on record. Mr. R. Dhar, learned additional senior government advocate, Assam, is present on behalf of the state on the request of learned counsel for both the sides. Let this writ petition be listed again after 2 weeks by tagging the rejoinder affidavit with the record of this claim. Yes, none appears for the writ petitioner when the matter is called up. The petitioner's counsel was absent. Even on the last date, when the matter was listed before this court, it appears that what is the matter about?
This is regarding they have challenged the appointment starting work at
It appears that the petitioner is no longer
they should be given the due wages if she
keen to pursue the matter before this court. Ms. M. Bhattacharjee, learned additional senior government advocate, Assam, is present on behalf of the state and submits that the relief prayed for by the petitioner is also not maintainable. Be that as it may, due to the absence of the petitioner's counsel on 2 consecutive occasions, this writ petition is dismissed for non-persecution.
Can you kindly pass it over for the time being? Mr. S. Bhattakur is on leg.
At the instructions, there were 3 petitioners that were left out. Their names were then placed before the remuneration committee. Their claims have been rejected, but I have the minutes.
Okay, can you share with him? Then we'll close by giving them liberty to challenge this. Let him come. Let Mr. Bhattakur. Time being.
Much obliged.
Pass over to the time being.
Percy in item 25, no extra copy has been served to us.
They are not giving extra.
We'll start today itself.
Mr. B. Sinha, counsel for the petitioners, assures this court that extra copy of the writ petition will be served upon the learned G. Assam during the course of the day. In view of the above, and on the request of learned counsel for the parties, let this matter be listed again after 4 weeks. In the meantime, the learned counsel for the respondents to obtain instruction. Ms. M. Bhattacharjee, learned additional senior government advocate, Assam. Ms. M. D. Bora, learned standing counsel. Cooperation Department, item 26. You are Mr. A.J. Sharma. Standing Council Cooperation Department. We'll record your name, 25 of Mr. Sharma and our present. After? Why? Not feeling well? Huh? Weather is not good. What is the matter about?
My lord, overstay in service, my lord.
Huh?
Overstay in service, my lord.
Who are staying service? You are still staying.
No, my lord. I have retired, my lord.
Oh, then we'll have it after some time. After 3 weeks.
my
I will
lord,
stay
after
connected
three-
learning council for the petitioner, huh? On the request of Mr. N. Upadhyay, learned standing council for the irrigation department. This writ petition be posted again for admission hearing after 3 weeks. Mr. P. Nayak, learned additional AG Assam bracket finance, and Ms. E. Sharma, learned G. Assam are present on behalf of the official respondents.
Deep lord.
On behalf of the other official respondents.
Well, possible for the time being senior council and then coming.
What is this matter about? Yes, what is the matter about?
Regularization, my lord.
Okay, time being.
In this case, my lord, petitioner already died, my lord, on 9/4, my lord. Legally, also ought to have filed a substitution petition, my lord.
So you want to file substitution?
Till with that, I have not filed, my lord, but ought to have been filed, my lord.
No, what is to be done? Tell me. Ought to have been filed, but you don't want to file, we'll close it. Mr. K.R. Padgari, counsel for the petitioner, submits that the writ petitioner in this case has expired on 9/4/2025, my lord. And as such, and since there is no surviving cause, what is the matter about?
Matter, my lord, regarding pensionary benefit, my lord, non-payment of pensionary benefit. It is service a regular master role worker, my lord. He overstay in
And
service.
therefore he be permitted 4 weeks time to obtain instruction and file appropriate application for substitution. The prayer is not opposed by learned counsel appearing for the respondents. S. Boro. Achha. Ms. R.B. Bora, learned standing counsel BTC, Mr. P. Nayak, learned additional AG bracket finance Assam, Mr. D. Bora, learned GA Assam, and Mr. R. Boro, learned counsel for the AG ANE Assam are present and do not have any objection if the prayer is allowed. In view of the above, let this matter be listed again after 4 months.
All right.
Lordship, may kindly produce the last order. My learned friend was required to file an affidavit in this matter on Friday last. Unfortunately, nothing has been served on us till date, Your Lordships. This is that matter regarding recruitment, and 3 or 4 occasions my learned friend has already taken time. It was in that context that Your Lordship had passed the order.
All right, any affidavit has been filed by the other respondent?
Yes, Your Lordship. Everyone else has filed. APSC has also filed supporting our case. AEGSL has filed an affidavit saying that it is the power department who had conducted the entire selection process, specifically the medical board. And therefore it is on them for, they are the ones who have not given the appointment to the petitioner concerned, Your Lordship. Now,
All right, so now their respondent number 6 cannot file any affidavit because
Get some instruction.
Hmm.
According to that instruction was received by me through the AGCL. The power department sent my letter to the AGCL. AGCL sent me their stand.
yes.
If that stand, Lordship, we have to take some response. According to my letter, the additional secretary to the government of Assam Power Department has request for conducting the medical fitness examination of the 77 numbers of.
No, but who is the respondent number 6? I find only
Power
5.
department.
they were included, Your Lordship. It was substituted by on 20th 12th 2024 by way of this honorable court's order. They were impleted as a party respondent, and I've also filed the amended cost title, Your Lordships. I filed it on 6/1.
Look, interview was there. Medical examination as per the arrangement. Then the government after appointment order giving the right of person disability. According to medical report, our this rank percentage is lower than the physical rate. Then the petitioner, he examined the again and submitted a 30 days. We cannot act on it, and therefore we ask the government to re-examine the petitioner on the basis of his 30 days. That has not been done by the government and therefore that's the problem. Now the government has to re-examine the petitioner for the medical.
All right. So what we'll do is, in view of this order, respondent number 6 cannot file affidavit now because that has been closed. So we'll fix this matter for admission hearing. You agree on a date, and on that day, Mr. Gosam will produce the records.
Lordships.
Choose a date in this second week of June so
Yes,
that they
I'm
get
happy.
sufficient.
Any date as
We'll have it on a
on a
non-miscellaneous.
non-miscellaneous day, Your Lordship. That would be very kind of Your Lordships.
All right. Can you agree on a date, all of you?
Lordships, 10th or 12th of June, subject to Your Lordship's
12th of June,
12th of June.
fixed item.
Yes,
Like that. You're right, like this.
it's no, a non-miscellaneous day.
Mr. Goswami always has a different plan for everything. But
What is
thank
your-
God he has not asked for 14th.
No, he's very happy on 14th.
Lordship, when
Non-miscellaneous, 12th.
17.
What will happen? Why not on
Why not
12th?
10th?
Why not on 12th?
Lordship.
You are going to Supreme Court? No, then
12th is also.
17. During this time, if required, I will.
you will? During this period, if required, you will?
Lordship, if instruct Lordship, I will participate.
Nothing, you can, the 13.5 order has
17,
debarred you.
and then
You have to challenge this order in a higher forum, otherwise you can't file any affidavit. You cannot file any pleadings now.
7.
Lordship, 17, my only apprehension is, and again, we'll be in the motion stage and all that, and
17 is not the most.
no, because we'll be too
See,
close to
Ms.
vacations.
Chaudhary, you realize now how difficult it is to have a consensus. Huh? Just on fixing a date, the
Absolutely.
court left it to the bar and there is 13,
I'm
14,
already
17, 18.
17, as per my learned
Yes,
friends
it will be
can
listed on 12th. Heard Ms. R.S. Chaudhary, learned counsel for the writ petitioner, also heard Mr. S. Kotaki, learned standing counsel AEGCL, appearing for the respondent numbers 1, 2, and 3, who submits that counter affidavit on behalf of his client has already been filed. Similarly, the stand of Ms. S. Kalita, learned counsel, appearing for the respondent number 4. First up, by the order dated 13/5/2025, one last opportunity was granted to the respondent number 6 to file affidavit. However, despite the deadline laid down in the said order, no affidavit on behalf of the respondent number 6 has been filed till today. Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the respondent number 6, also could not furnish any proper explanation for not doing so. Be that as it may, in view of the urgency involved in the matter and on the request of learned counsel for the parties, let this writ petition be listed again on 12/6/2025 as a fixed item for admission hearing in the top of the column of admission matters. The writ petition will be taken up for disposal on the basis of pleadings already available on record. The learned government advocate, additional senior government advocate Assam, to positively produce the relevant records on the next date, facilitating disposal of the writ petition.
Lordship, may kindly continue the interim order till that day. The
Interim
interim
order
order.
passed earlier to continue.
And DP of life. Made please.
Sorry?
Regarding the promotion from group, to the postman. In this case, but in the time-bound promotion, there was a fee gets due to the pendency of the criminal case. He was denied from lawsuit as part of our policy, and accordingly, we have next our seat cover proceeding as well as the review orders passed by the committee, which was communicated to the police.
So there is a affidavit in reply filed on 21 yesterday. You have received a copy.
Yes.
What do you want to say?
Can it be taken after some time, Lordship? Then a short date may be given, Lordship.
You agree on a date? Let us see if you can agree.
Monday, Lordship.
3rd June. Miss so-and-so, your
B.
name?
Devi, Lordship.
Huh?
B. Devi, Lordship.
Miss B. Devi, learned counsel for the petitioner. Some is that the affidavit in reply filed by the petitioner on 21/5/2025 is already on record, and therefore this matter is ready as regards pleadings. As such, the learned counsel for the petitioner seeks posting of the matter on a non-litigious day for early disposal. Mr. M. Kalita, learned counsel. K. Kalita, learned counsel for the respondents, is present and is agreeable to such a request. In view of the above and on the request of learned counsel for both the sides, let this writ petition be listed again on 5th of June for admission hearing as a fixed item. What is the problem with 5th of June? That will happen 3rd of June.
Matter has been sent to us in his office, and we are considering. It has been sent to us, which have no instructions.
Yes, 33, my lord, the respondent number 5 submitted, my lord, affidavit.
You are appearing for?
AG.
That is respondent number?
4, my lord.
So Mr. K. R. Padgiri, learned counsel, is present for the petitioner. Mr. D. Bora, learned G. Assam, is appeared for the state. You are appearing? Mr. J. Hendig, learned standing counsel for Revenue Department, Assam, is present on behalf of the respondent number 1. And Mr. D. Bora, learned G. Assam, for respondent numbers 2 and 5. Mr. D. Bhattacharya, learned standing counsel, Office of AG A&E, Assam, appearing for the respondent number 4. Prays for 3 weeks' time to complete his instruction. and make submissions before the court. Since the prayer is not opposed, same stance allowed, let the matter be listed again after 4 weeks. My lord.
Oblige.
As a fixed item.
Item number 14, we are receiving the copy of the, by today, we can file by tomorrow. Can it be in the first week of for admission? Concluded on the day, there is an interim order operating in the second term. This is why we are in a urgency.
Lordship, will file our reply, Lordship, in item number.
So we'll have it next Wednesday.
And, no,
You file it by tomorrow and they will file their response by next Tuesday.
after 2 weeks, Lordship.
No, there is an interim order. Then we'll not extend the interim order. 4 weeks.
Okay,
What do you want?
okay, next week, Lordship.
Next day. Ms. P. Borwal and a counsel is present for the writ petition and both these writ petitions. Mr. U.K. Goswami, learned CGC appearing for the respondent submits that the counter affidavit on behalf of the respondent will be filed by tomorrow. Contending that there is urgency involved in the matter due to operation of interim order. Mr. Goswami has prayed for posting this case on an early date. Taking note of the submission made by Mr. Goswami, this writ petition is directed to be listed again on 29th of May 2025 as a fixed item. The counter affidavit on behalf of the respondents be filed by tomorrow after serving advance copy upon the petitioner's counsel. The writ petitioner may file rejoinder thereafter if so advised on or before 28/5/2025. Let these writ petitions be listed as fixed items on 29/5/2025.
Interim order.
Interim order passed earlier to continue till then.
Privilege and Lordship. This case, Lordship, notice has been issued, Lordship. The matter pertains to non-release of disability element, Lordship.
Yes, who is appearing? Yes. Sorry, speak louder, speak in the mic.
March 2004, Lordship. And thereafter,
2004.
2004, we wrote to the bank authorities on.
No, what is your instruction in this case? This is 2025 matter.
Yes, Lordship, we have wrote to the bank authorities that why the pension has not been released. So it is upon the bank authorities to.
Who is appearing for the bank?
Lordship, kindly allow us some time to file our reply, Lordship, in this matter.
You are appearing for respond numbers?
Respond number 7, 8, 9.
And who is appearing for respond number 6? And 4, 5. So you take your name. Who is appearing in this case? Mr. K.K. Parasal and counsel for the CGC has appeared on behalf of the respond numbers 1, 2, and 3 and submits that the pension payment order pertaining to the petitioner has already been issued long back, and therefore it is not understood as to why the bank has not yet credited the requisite amount in petitioner's account. Full stop. Mr. C.K.S. Borwa, learned G. Assam, appearing for the respond number 4 and 5, and Mr. P. Nayak, learned additional AG bracket finance bracket to Assam are present on behalf of the respond numbers 4, 5, and 6. Miss, your name, please.
S. Yasmin on behalf of M. Sharma.
Mr. M. Sharma, learned counsel appearing for the respond numbers 7, 8,
7,
and 9 has prayed for 3 weeks further time to file affidavit responding to the allegations made in the writ petition. Prayer allowed. However, it is made clear that if no affidavit is filed within 3 weeks from today, then the writ petition will be taken up for disposal based on the materials already available on record. Registry will release the case again after 4 weeks.
A date will be fixed.
As a fixed item. You calculate the date.
Much obliged, Lord.
May I please? Matter relates to recruitment in defense. He is qualified in the exam, but grievance is that his EW side was not calculated, not taken into consideration. On that ground, we are before this honorable court.
He was recruited in the in BSF, Lordship. He has get appointment.
That is correct, my lord. But if his EW
But
side
he
was
does
taken
not
into
join.
consideration, he's supposed to appoint in CISF.
We received instruction, Lordship. We have received instruction, Lordship. I want to file affidavit. Otherwise, he offered appointment on BSF, but he has not
That is
joined.
declined.
Yes.
Let her file the affidavit. Heard Mr. K. Raman, learned counsel for the petitioner, Ms. S. Burwal, learned CBC appearing for the respondents, submits that she has received instructions and therefore be granted how much time?
3 weeks, Lordship.
3 weeks time to file affidavit. Prayer allowed, let the matter be listed after the affidavit is filed.
Obliged.
Yes, for the petitioner when the matter is called up, matter stands pastoral for 2 weeks. Mr. D. Boral and G. Asam is present for.
Your lordship, in this matter, we have sent the affidavit for vetting.
Matter stands pastoral for 2 weeks, yes.
May I please, Your Lordship? My lord, here in the case, my lord, the petitioner is going to retire by 31st of this month, my lord. And he was placed under suspension, my lord, but no review has been done with the reason order, my lord. Though they filed the affidavit does not disclose, my lord, that the reason order has been passed for extending the review in terms of the honorable court's order, my lord. There is a platina of judgment, my lord. They need to have passed, my lord. Lordship, kindly have a look at judgment, my lord, passed by this honorable court, my lord. Even, my lord, I have marked, my lord, yellow portion. Even by filing, giving the charge sheet, my lord, they need to have passed the reason order. Other judgment is also there, my lord, the projected, my lord, they need to have a reason order. But no reason order has been passed for extension of the suspension. Though affidavit did not disclose, my lord. Aru judgment আছে to দিয়া নাই 1 2 দিয়া রফিকুল আরো কি কি আছে না 1 আছে
Yes.
Here in the case, my lord, a copy of the show cause was served upon me. And I replied to that, my lord, at page 38. But no review, my lord, for extension seeking further extension of the suspension has not been reflected. In the affidavit, it is totally silent.
They have filed affidavit.
They filed, my lord, lordship, it is, if it is there in the record or not, then, my lord, I have received yesterday, my copy. Lordship can have a look, my lord, does not.
No, then we'll have it posted next week along with the
My lord,
affidavit.
I'll be retiring.
We'll either pass an order setting aside or dismiss your writ petition by next week. What is the problem?
Lordship, can it be Friday, my lord?
Then it will go to some other court.
No, my lord, let it be your lordship. Your lordship's convenient, man.
No, no. What is the problem? You're retiring, so what will happen? Tomorrow you want an order, then you will get a promotion, then
No, my lord,
become
at
a
least
commissioner,
stick
something
back
like
to
that.
the- Lordship will pass a appropriate order.
Don't make
Lordship,
submissions as if you are the client. Don't do that.
Lordship.
Yes, Mr. J. Borby, Learning Council submits that the GMC authorities have filed an affidavit in this case yesterday. However, the same is not on record. The learned counsel for the petitioner has expressed urgency in the matter by contending that the petitioner is due for retirement on 31/5/2025, and therefore an urgent order is called for in this case. Mr. P. Nayak, learned standing counsel, GMC authorities, as well as Mr. CKS Borua, learned GA Assam are present on behalf of the official respondents. Since the counter affidavit filed by the respondents is not respond number 2. Office to list this case again on Monday, that is 26 so and so, by tagging the counter affidavit of the respond number 2 with the record of this case. The petitioner would be at liberty to file rejoinder. In the meantime, if so advised. We'll take up the matter for disposal. Either we'll set aside the suspension or we'll dismiss the writ petition. But he has to retire by knowing where he stands. So we'll dispose of the writ petition on Monday. God bless. You take back this, please. Take back your decorated copy of
Next
order.
time I'll correct it. It was my office copy.
Good decoration.
I'll give the fresh copy.
Yes.
Yeah, please, your lordship. Two writ petition, my lordship. First,
Sorry?
two writ petition filed by the petitioner, my lordship. The first writ petition, my lordship, his grievance was that his application for compassionate appointment was not considered. During pendency of the writ petition, the state department they submitted an affidavit stating that the state level committee has rejected the application. By challenging the minutes of the state level election committee, my lordship, I have filed second writ petition. In the second writ petition, they have filed affidavit that they will place the application before the SLC, my lordship. Kindly peruse the paragraph 5 of the affidavit in opposition, page 45.
Yes, paragraph 5.
Paragraph 5. May I read, my lordship?
Yes.
That with regard to the statement made in paragraph 9 of the writ petition, the deponent begs to state that the proposal for appointment on compassionate ground in respect of Sri Mithun Nath, son of late Mankumar Nath, was received along with duly signed checklist. From the available records, it is found that the father of the petitioner, late Mankumar Nath, expired on 8/1/1994 as per the death certificate, and as per the checklist, the date of application of the petitioner is 13/6/2007. The minutes of the DLC meeting held on 7/10/2009 reveals that the petitioner was recommended for the post of AB Constable. On 9/12/2011, the meeting of the SLC was held, but SLC could not recommend the candidate for appointment on compassionate ground due to the following reason: late submission of application applied after 1 year from the death of the government servant. However, the Honorable High Court in judgment dated 1/12/2022 passed in WBC 7059/2021, Rituraj Shitya versus Sir, had observed that in case of compassionate appointment, the scheme prevailing on the date of death of the employee would govern the claim. Hence, in the light of judgment of the Honorable High Court mentioned above and the applicable OM of that period, this department has decided for placing the case of Sri Mithun Nath before the next SLC. This is my case, my lord. I was a minor when my father was died. My mother also expired before my father. Page 17 may be seen also, my lordship.
What is 3982 WPC? This 6990 2021 WPC?
Yes, my lordship. This is my first writ petition, my lordship. They have not communicated the outcome of the SLC, my lordship. In that circumstances, I filed this writ petition unaware of the fact that SLC had rejected. And
Yes, what do you want to show in page 17?
page 17 is that, my lordship, even I was called for I was called for by the department, my lordship, for training also, my lordship, by the police department.
So now you take a decision as per the stand taken in your affidavit.
My lord, the affidavit was of 2023, my lord. Thereafter, my lord, these affidavits filed on 2023, my lord. Thereafter, my lord, the government has come up with an OM in 24, my lord.
That is subsequent to this.
Subsequent, my lord. And my lord, this decision, what we referred to, my lord, again, I have come across, my lord, a judgment of the Honorable Supreme Court, 3-bench, my lord. It's a full bench, my lord. It's the contrary, my lord. What the law has been settled there, my lord, regarding compulsion appointment, regarding the date of, my lord.
No, we are not getting into it. You have taken a stand, we'll dispose, you do whatever you want to do. You'll face the consequences. We can't now, how can you now argue against your affidavit? How can the court pass an order which is contrary to the affidavit? And your judgment of 3rd April clearly says pending cases are to be considered.
Yeah, only where the OM is challenged, my lord.
That you figure out. We
my
are
lord,
not getting into it. Heard Mr. S.B. Lashkar
my
and
lord,
counsel for the.
my lord, that will become that is what my lord, what I on the last occasion even I, my lord, my lord, submitted that. Let them, my lord.
No, you are creating the mess. You are creating the mess. You are in some cases you are constituting SLC. In some cases you are saying no. You are not coming up with a clear stance. If you have withdrawn the scheme in 2016, then why has the SLC been convened in so many occasions after 2016 or 2017? And some cases you are saying will consider, some cases you are saying will not consider.
My lord,
you are conveniently taking a stand whenever it suits you.
No, that is not exactly the case, my lord.
No, you first explain one thing.
My lord.
If your consideration was that the application is belated and it has come after so many years and the scheme has already been withdrawn, why have you taken this stand in the affidavit? This is not a joke. It's a court proceeding. This affidavit has been sworn by a responsible officer. Is it not?
Yes, my lord.
Why has this affidavit been sworn?
My lord,
and now you are arguing against the stand taken in the affidavit.
No, my lord, I am on the law, my lord. So what Supreme Court said, my lord, regarding this, my lord, because we were
Law
on
will
this,
follow facts.
We followed, my lord, this honorable court's single bench judgment, my lord, day of consideration. That is, so this has been, my lord, subsequently.
You consider and take a decision there. If you think law doesn't permit you, don't do it. We can't comment on that. Heard Mr. S.B. Lashkar and counsel for the petitioners, petitioner in both these writ petitions. Also heard Mr. R. Dhar, learned additional senior government advocate Assam, appearing for the state. First up, the facts and circumstances giving rise to the filing of this writ petition are as follows. Full stop. The petitioner's father, who was a grade 3 employee and was serving as AB constable in the office of Superintendent of Police Hailakandi, died in harness on 8/1/1994, leaving behind the petitioner and his widow as surviving legal heirs. Full stop. Upon attaining majority, the petitioner had submitted an application. At the time of the death of his father, the petitioner was a minor. However, upon attaining majority, the petitioner had applied for appointment on compassionate ground. His application was considered by the DLC Hailakandi and by resolution dated 7/10/2009, the same was recommended for appointment against a post of AB constable. Full stop. The matter was thereafter placed before the SLC But when no action was taken in respect thereof, the petitioner had approached this court by filing WPC number 6990/2021. Full stop. The respondents filed counter affidavit in the aforesaid writ petition inter alia contending that the SLC had rejected the application of the petitioner by resolution dated 14/12/2011 on the ground that the application was belated. Full stop. According to the petitioner, no intimation about the rejection of his application by the SLC was ever furnished to him, and he came to know about the same for the first time from the counter affidavit filed by the state in WPC number 6990/2021. First up. Accordingly, WPC number 3982 of 2023 was instituted by the petitioner, assailing the decision of the SLC as recorded in its MOM dated 19/12/2011. First up. The respondent number 1 had filed affidavit in opposition in WPC number 3982 of 2023. The averments made in para 5 of the counter affidavit would be pertinent for this case, and therefore the same are being reproduced herein below for ready reference. Full stop. The court correlate will be page 45-46 of the counter affidavit. Full stop. From the above stand of the respondent number 1 as reflected in para 5 of the counter affidavit, it is clear that the respondents are willing to act in terms of the judgment and order of this court passed in the case of Rituraj Chetia versus State of Assam and others, wherein it has been held. Which para is relevant? Rituraj Chetia, which para?
Rituraj Chetia, my lord, para 4.
Wherein it has been held that in case of compassionate appointment, the scheme prevailing on the date of death of the employee would govern the claim. Full stop. Mr. Dhar Learned Additional GIA Assam submits that considering the lapse of time in this case, the claim of the petitioner would stand extinguished not only under several decisions of the Supreme Court, but also judgments of this court, and therefore, regardless of the stand taken in the counter affidavit, the case of the petitioner cannot be considered. Full stop. I am afraid the above submission of Mr. Dhar cannot be accepted. Full stop. Once the state has taken a stand by filing a counter affidavit, they will be bound by the above stand. Full stop. Therefore, the learned government advocate cannot be permitted to argue in a manner which is contrary to the stand projected in the counter affidavit filed by the state. Stop. What effect law will have on considering his claim, the matter which would no longer survive for consideration for this court in view of the stand taken in the affidavit filed by the state. Considering the above, this writ petition is therefore disposed of by providing that the case of the petitioner be considered in the light of stand taken by the state in para 5 of the counter affidavit, and appropriate decision in that regard be taken as expeditiously as possible, but not later than 90 days from the date of receipt of a certified copy of this order. Writ petition stands disposed. Both the writ petitions stand disposed of accordingly.
Highly agree, my lordship.
May I please, your lordship, my lord, I'm sorry for out of turn, my lord. Item 51, my lord, is very important. I have missed, my lord. I am so misread perhaps the display board. Since morning, I am waiting for the matter, my lord. Very
Today
urgent
it will
matter,
not
my
be
lord.
possible.
My lord,
What order has been passed, 51?
none appears, my lord. I was waiting outside, my lord. Somehow I missed it. Regarding my lord, recruitment matter, police constable, they are going to appoint, my lord, selection challenge, my lord.
After 2 weeks,
My lord, maybe on Friday, my lord. Yes, my lord.
rejected, not possible.
My lord,
No, after 2 weeks, 3 weeks or 2 weeks holding. Yes,
a date may be fixed, my lord, at least, my lord.
after 2 weeks it will come.
Oh.
Next Friday.
I'm seeing it. There's, I think, 12.
So we'll finish. There are 2, 3 other
Yes, yes,
cases and then
no problem.
this will take some time.
Yes.
Yes.
24.
Here, your lordship,
Yes, he's saying that the
so
case.
far as 3 petitioners are concerned, your lordship. Let me have a
Then
copy
that
of that. Your
challenge
lordship.
that.
I will have to challenge that.
We'll close it then by granting liberty. How many petitioners are there in total?
Your lordship, there are altogether
14
14
petitioners, my lord.
petitioner, your lordship.
And whose cases have been considered?
11 have been considered, my lords. Petitioners number 4, 8, and 13, my lords. Their claims
4, 8 and 13 has not been.
And what about the others?
others have been given the benefit of enhanced remuneration.
4, 8, and 13.
Agenda 3 is relevant, my lord. Page 2.
I heard Mr. S. Bothakul and counsel appearing for the writ petitioners. Also heard Mr. D. Chaudhary, learned standing counsel APDCL Assam, who has produced a copy of the resolution adopted in the meeting of the Remuneration Committee of APDCL held on 8/5/2025. First up, a perusal of the minutes of the meeting recorded on 8/5/2025 indicates that save and accept the writ petitioners in serial numbers 4, 8, and 13. The authorities have accepted the claim of the other petitioners for grant of enhanced remuneration. However, the claims of the respondent numbers 4, 8, and 13 have been rejected on the grounds recorded in the minutes of meeting. First up, if that be so, it would now be open for the petitioners numbers 4, 8, and 13 to assail the decision of the authorities by filing fresh writ petition. In view of the above, on the request of, have you got a copy of this?
Just now I have been.
In view of the above, and on the request of Mr. Bothakul, learned counsel for the petitioner, this writ petition stands closed by granting leave to the petitioner numbers 4, 8, and 13 to avail legal remedy as may be permissible under the law. Appropriate legal remedy as may be permissible under the law.
Keep your measure.
Obliged.
Item 38.
May I please, my lord? Here petitioner is a, my lord, national basketball player, my lord, who is working, my lord, as a, my lord, Safai Kormosari, my lord, daily wage basis, my lord, grade 4 employee, sweeper, my lord. From 33/2013, my lord, he is working, my lord, continuously without any adverse remarks against the petitioner, my lord, continuously working in the Directorate of Sports and Youth Welfare Department, my lord. Sometime he also sent as a, my lord, assistant coach as a basketball. Everything is in the pleading, my lord. My humble submission before your lordship is that I pray for regularization of the service of the petitioners, my lord. But it was not considered, my lord. They have stated, my lord, we have annexed in our affidavit in reply, you are not fulfill the condition of Uma Devi, my lord. That first, you are 1/8/2006,
You are not completed 10 years of service. You did not, secondary possess qualification, no? Waiting, madam. Did not possess qualification, madam, third two. There is no sanction taken, board. My lord, this is only post as a Safai Kormosari in that director or sportsman. I have categorically stated they are not denied, my lord. Meaning thereby his duties are perennial in nature, my lord, permanent in nature, my lord. To that aspect, my lord, a judgment of the apex court in respect of Safai Kormosari has come, my lord. That board, this is copy to the copy there, no? Jaggo, my lord, in that judgment, I shall submit, my lord, and facts is identical with me, my lord. It's subject to correction of my learned friend, my lord. Lordship, kindly come to the para, my lord, first, para 9. SLP number to likhi lo tumi. Etu 5850 this is SLP number 209. Etu aru eta ase. The para, my lord, 9. May I read slowly, my lord. On the other hand, first, my lord, para, you lordship come to the para 8, no? Para 8. On behalf of the appellant, para 8, my lord, the following argument has been advanced before our continuous and substantive engagement. The appellant emphasizes their long and uninterrupted service spanning well over a decade. In some instances, exceeding 2 decades, they argued that their duty were neither sporadic nor project-based, but permanent and integral to the daily functioning of the respondent office. Nature of duty, the responsibilities such as cleaning, dusting, gardening, other maintenance tasks were not casual and peripheral. Instead, they were central to ensuring a clean, orderly, functional work environment, effectively aligning with role and typically associated with regular post absence. In this case, what happened, my lord? These petitioners all are Safai Kormosari, they are working, my lord. Subsequently, they are terminated from the service, they are moved before the tribunal. They are also paid for regularization of the service of the petitioner, my lord. Although they have kept, my lord, like that open does, subsequently Supreme Court has said, my lord, High Court kept, my lord, Supreme Court has said, no, you have kept this person for a long period, my lord. And they are Safai Kormosari. And why you need the educational qualification this time? As most important thing is that, my lord.
Yes, I wonder, have you gone through this judgment? What do you have to say? What is the post of Safai Kormosari? Is it a regular post?
No.
Then,
It's not saying it is a sanctioned vacant post, your lordship. They're just.
but you need him for last 12 years. He's been working.
He was engaged on 2013 only.
Yes.
So regarding this regulation, of course, Uma Devi comes to the paragraph 53 comes to the fore, your lordship. Now, I don't know whether this judge, I have not gone through the judgment because I have not been supplied with a copy also, your lordship. I am not aware.
When you go through the judgment, we'll take up on Tuesday for
Yes, my lord.
disposal.
In that case, my lord, Uma Devi has been distinguished, my lord.
No, let him go through the
Yes,
judgment.
yes,
We'll take
yes,
it up on
yes.
Tuesday. Mr. NNB Chaudhary, learned counsel appearing for the petitioner submits that this writ petition is covered by the decision of the Supreme Court rendered in the case of Jaggo versus Union of India and others. Rendered in SLPC number 5580 of 2024 and the connected proceeding. And therefore, the writ petition be disposed of by issuing a writ of mandamus upon the respondents to regularize the service of the petitioner. Mr. D. Bora, learned government advocate Assam, submits that he requires some time to examine the aforesaid decision of the Supreme Court. First of, in view of the above and on the request of Mr. Bora, when do you want it? Next Tuesday or Thursday you decide?
27 or 29? Doesn't matter.
27.
27.
27 or 29?
27.
27. This writ petition be posted again on 27/5/2025 as a fixed item for admission hearing. In the meantime, Mr. Bora to obtain specific instruction in this regard. Let it come up.
Lordship, grievance has already been compliance
Matter may be withdrawn.
What?
Grievance has already been compliance, Your Lordship. Matter may be withdrawn.
Grievance has been redressed. Your name, please?
R. Dutta.
Ms. R. Datta, learned counsel appearing for the writ petitioner submits that the grievance of the writ petitioner has been redressed during the pendency of the writ petition, and therefore this matter be closed. Ms. Bora,
And Bora.
Ms. N. Bora, learned standing counsel, PNRD Department, Assam, Mr. P. Nayak, learned additional AG bracket finance, Assam, as well as Mr. B. Chakravarti, learned counsel for the Office of AG A&E Assam are present for the respondents. Taking note of the submission made by the petitioner's counsel, this writ petition stands closed.
Also, may clearly see the order dated 8/5/25 Lordship. It's a Lawajima order, Lordship. They are supposed to take steps upon respond number 89. Despite 2-3 opportunities has been given, they have not complied with the order. So it has been written that they are not interested in pursuing the case. Eight five 25.
What is the subject matter of this?
Subject matter is that Lordship, village defense party Lordship, the quorum was there. After that Lordship, the quorum expired after 5 years. And Lordship, all the earlier persons, Lordship, the president, secretary, they were supposed to be the member of the next PDP in the next quorum, Lordship. But instead of that, Lordship, some new members have come in. So why is the reason, Lordship? We have filed an affidavit, Lordship. In our affidavit, we have mentioned there's some written complaint against the earlier existing members. So that is one of the reason, Lordship. The new members have come in. In the affidavit, Lordship, para number 4.
All right, none is appeared for the petitioner. Mr. C.K.S. Borua, learned G. Assam is present on behalf of the official respondents. Office note dated 8/5/2025 indicates that the writ petitioner has failed to comply with the order of the Lawajima Court for taking steps for service of notice upon respond numbers 8 and 9. As such, an observation has also been made by the Lawajima Court that the petitioners, let us see. That the petitioners may not be interested in pursuing this matter any further. Having regard to the nature of relief paid for in the writ petition, the aforesaid observation made by the learned Lawajima Court appears to be justified. Similarly, the stand of Mr. C.K.S. Borua, learned G. Assam appearing for the state. In view of the above, this writ petition stands dismissed for non-prosecution.
Possible.
Yeah, please, Lord. My lord, we have taken steps to justice service, my lord, but the thing is that we could not file the affidavit because we have lost contact with the client, my lord. So may I pray that we take fresh steps again, my lord, to registered post, my lord, upon the respondent number 3 and 4, my lord. The
Your
Guwahati
name, please?
A.N. Sharma, my lord.
Mr. A.N. Sharma, learned counsel for the petitioner, submits that all those steps by way of dusty service was taken for service of notice upon the respond numbers
3 and 4, my lord.
3 and 4. Yet, since the council has lost contact with the client, no affidavit in compliance of such order of the court could be filed. As such, Mr. Sharma prays for leave of this court to take fresh steps for service of notice upon respond numbers 3 and 4 by registered post with AD. Leave granted, steps within a week for service of notice upon respond numbers, fresh steps within a week for service of notice upon respond numbers 3 and 4 by registered post with AD by making the notice returnable in 4 weeks.
My lord. Oblige me.
May I plead your lordship, grant me 1 week time for fresh step upon respondent number 8.
On the prayer of petitioners council, 1 week's further time is granted for taking steps on respond number 8. Registry to list the matter accordingly with appropriate office note. Interim order subject to taking steps within a week from today. Interim order passed earlier to continue until further orders.
Lordship, in this, Lordship, in this particular case, the grievance of the petitioner with regard to as to whether the subsistence allowance has been paid to him or not, we have to obtain instructions from the client, which we have not obtained yet. We have tried to get in contact with the client, but the client is not addressing our concerns.
Mr.
M. Bhuya, Lordship.
M. Bhuya, learned counsel appearing for the petitioner 6 adjournment in this case for 4 weeks so as to obtain updated instruction as regards payment of subsistence allowance, if any, to his client. Since the prayer is not opposed, same stands allowed, list accordingly.
Much obliged.
Please, your lordship. Lordship, the petitioner is a retired executive engineer, superannuated in the year 2017. And lordship may kindly peruse your lordship's order dated 23/10/2024. Lordship.
Yes.
And in the meantime, lordship, he received all the pensionary benefits, including regular pension, gratuity, provident fund. He received everything, but DP is still pending since 2018, lordship. It is not concluded.
So the writ petition is disposed of.
Yes, lordship.
Then what is this IA for?
IA for all the pensionary benefits, but we receive all the pensionary benefits.
All right, then we'll close it.
Lordship.
All right.
And lordship, only the thing, DP is still pending, lordship. This is the
No, that cannot be dealt with in the IA. You have to take further action.
Lordship.
Not in the IA. This IA was filed for implementation of the order dated 23/10/2024.
Yes.
All right. Heard Mr. T.K. Mishra, I counsel for the applicant. Peruse the statement made in the IA. The instant IA was filed primarily modify the order. Why you wanted to be modified?
Actually, in the last order, your lordship ordered for provisional pension, but he already received provisional pension.
For modification of the order dated 23/10/2024 passed by this court in WPC number 4095 of 2024. However, during the pendency of this application, the applicant stroke writ petitioner. However, it is submitted at the bar that during the pendency of this application, the applicant stroke writ petitioner has received all his pensionary benefits. If that be so, nothing survives in this IA. As such, this IA stands disposed of.
And regarding lordship DP?
That cannot be ordered in the IA. Then
Lordship.
you have to file a petition.
We'll have to file
Yes.
one. Lordship. I'm obliged.
May please, lordship, as per Lordship Court order dated 8/5/2025, lordship. Service is complete, lordship.
Heard Mr.
MS Alam.
Mr. S. Alam, learned counsel for the petitioner. It is the Luajima Court order dated 8/5/2024, which goes to show that service of notice in this case is deemed to be complete. Mr. Du Pamanu, learned Standing Counsel for Health and Family Welfare Department, Ms. U Sharma, learned GA Assam, Mr. Huh?
1 and 7.
No, we are not giving names. Mr. P. Nayak, learned Additional AG, bracket Finance, bracket Assam, and Mr. B. Chakraborty, learned Standing Counsel for AG ANE Assam, are present on behalf of the official respondents. Since this matter is ready as regards service, it's registered to list this case in the admission column after 3 weeks. Yes.
Instruction awaits your also.
Instructions awaited. How much time you want?
Lordship, 2 weeks time.
Dr. B. N. Gogoi, learned counsel for the petitioner, is present on the request of Mr. G. Bordoloi, learned Standing Counsel Cooperation Department, Assam. 3 weeks further time is granted to him to obtain instruction. Mr. P. Nayak, learned Additional AG, bracket Finance, bracket Assam, is present on behalf of the respond number.
I appear for 1, 2, and 3, your Lordship.
1, 2, and 3 would you, and he will be respond number. Nobody knows.
5, 5.
We have to keep another person to find out who you are appearing for, huh? You also don't know.
So it's the co-person department.
Respondent number.
Respondent number is not.
Lordship, finance is not a party in this.
Not
matter.
finance is
Then why are you appearing? No, like
1 to 3. 1 to 3 I'm appearing. Also. 4 is a private person.
why you are appearing then?
Already filed an affidavit for the matter.
Why have you filed? You are not even a party. All right.
All right. Deeply honest.
May I appear? My lord, this is non-payment of pension, my lord. They are supposed to take instruction. My pension has been held up. We have already submitted all the documents, is page 37 onwards.
Who is supposed to pay your pension? Nobody is there.
My lord, this is CRPF.
No CGC is there.
Last occasion K Google was appeared.
A Gogoi.
Yes, sir.
You see.
Yes, joint director of account paying.
That's right. K Gogoi CGC.
CGC.
Find out where he is. Time being passed over.
Thirdly, in this matter, my lord, I'm seeking for correction of the address of the respondent number 9, my lord. Earlier, my lord, itself was taken on respondent number 9, but the notice was returned unserved. So, my lord,
Correction means
address of the respondent number 9, my lord.
correction in the order or in the
No, my lord, in the
Post title.
post title, my lord.
post title of the writ petition.
Earlier, also, my lord, one IA was filed and that IA was allowed, but in the order, my lord, there was some my lord, mistake, my lord.
So this will be amendment of the writ petition. Where is the correct address?
The correct address, my lord, your lordship will find page number 5, my lord. Respondent.
No, you withdraw it and file afresh. You can't file these applications. This court will not accept. You have to mention in your petition what is the correct address according to you. You just mention some address here and some address there. That will not work.
Well, earlier, my lord, one IA was filed, my lord. That IA was allowed, but in the order of the IA, my lord, instead of
I have understood that. You have given another address now as regards respond number 9 in the array of parties. Correct. But you have to mention in the petition what according to you is the correct address. We can only act on that.
Well,
you have yourself corrected the address. Why you want a court order then?
my lord.
You have not understood.
My lord, I have understood, my lord.
You have to.
My lord.
Because these are matters which goes into the system.
Lordship.
We can't change it.
Lordship.
You want to withdraw?
My lord, I want to do.
On the request of Mr. M. Islam Nayak Counsel for the MA Islam Nayak Counsel for the applicant, this IA is permitted to be withdrawn with liberty to file afresh after making necessary rectification in the cost title. Mr. B. Sharma, learned
For AG, my lord, respond number 4.
Standing Counsel AG ANE Assam, RB Bora.
RB Bora for BTC.
RB Bora, Leonard, SCBTC, Miss N Bora, Leonard, Standing Council for PNRD Department Assam, Miss E Sharma, Leonard G Assam, and Mr. P Nayak, Leonard Additional AG Assam Finance are present on behalf of the respective respondents. IS stands disposed of on withdrawal with liberty to file a free. You put that address
My lord,
saying that this is the correct address. Otherwise, how do we know?
my lord, my lord. All right, my lord.
Yeah, I lordship, I filed another IA now and where is page 3, your lordship, my petition, para 3. Service on 31/1/2001.
Somebody is there for the respondent.
He is there.
Lordship, I will be here.
Huh?
In this case, Gupta is the other, I will be here, Lordship.
Okay, any objection?
No, Lordship, that part.
Heard Ms. K. Yadav, learned counsel for the applicant, also heard Mr. K. Gogoi, learned CGC appearing for the opposite parties. This IA has been filed with a prayer to carry out correction of certain typographical errors appearing in the judgment and order dated 3/4/2025 passed by this court in WPC number 6268/2017. The corrections sought by the applicant stroke writ petitioner are as follows. Para 304 to quote করে দেব। Mr. Gogoi, learned CGC appearing for the respondent submits that he would have no objection if the prayer made in the application is allowed by this court. In view of the above, the IA is allowed in terms of the prayer made in the application. Consequently, the date of discharge from service of the petitioner would be read as 31/10/2001 in the judgment and order dated 3/4/2025. That apart, the date of appointment of the petitioner shall be read as 23/5/2001 in the said judgment. In the said judgment dated 3/4/2025. The judgment and order dated 3/4/2025 stands modified to the above extent. Modified / clarified to the above extent. IS stands disposed of.
Your lordship, one more that in para 3, representation date is 31/1/2004, which ought to have been 21/1, not 31. Para 3.
The date of representation submitted by the applicant would be read as 21/1/2004 instead of 31/1/2004. উপরও কেটা to 31/10/2001 instead of instead of তিনটা correction date. Yes.
Much obliged.
Christian Lordship, I have sent the affidavit for vetting, Lordship. On 23rd April, I have sent it, so Lordship may give.
2025 matter will grant him how much time?
2 weeks, Lordship.
Mr. S.K. Deori, learned counsel is present for the petitioner on the request of Mr. K. Gogoi, learned CGC. 2 weeks further time is granted to him for filing affidavit.
For filing affidavit, Lordship.
For filing. Let the matter be listed again after 3 weeks as a fixed item.
Lordship.
Can be addition, sorry.
So this will take a little time. Let us start at 2.
My lord.
Start at 2. This is the only matter left. Only matter. What was the key issue here?
Compassionate family pension. The scheme says 1 year continuous service. The petitioner, he was initially appointed in pursuance to an advertisement selection process, interview, instead of giving him substantive appointment, they kept him under fixed pay. Thereafter, he was regularized. But the regularized service did not come down to 1 year. But on that count, they say you don't have 1 year regular service, but the requirement of the scheme is 1 year continuous service. My contention is that continuous service means service without break. So there was no break in his service. He continued, although he was in fixed pay, he continued for 7 odd years. Thereafter, he was regularized. Now, on that count, they're not giving the widow compassionate family pension. Since 2017, she is entitled.
At two.
Much of it.
Yes.
Lordships heard the matter at length in the earlier occasion, but I'll refresh your Lordships, my lord, with the facts. First of all, Lordship will kindly have a look at the scheme, what the scheme says, my lord. Then I'll take your Lordships to the relevant facts. Page 54 of the writ petition is the scheme. And the clause that which we are concerned with is at page 55. Para 5.3, subparagraph. However, the government must complete minimum 1 year of continuous service without break before death while in service. So we are concerned with this particular subparagraph, my lord. 1 year continuous service without break. Now, Lordship will kindly come page 29 of the writ petition. This was an advertisement issued by the BTC authorities. Lordship's got my page 29.
Yes.
Applications are invited from Indian citizen of male, female deserving candidate with duly filled in standard form affixed with 2 recent passport size photograph with attested copy of educational qualification, etc. for recruitment and filling up of the vacant post lying in the council, head of department, office stroke district and subdivisional offices of BTC area as per the details of the post given below. Junior assistant stroke LDA grade 3. The husband of the petitioner, he applied for junior assistant post. Now, in page 30, there are 2 important clauses in this advertisement. H and I. Candidates who are already engaged to the office of the CHD district subdivisional offices on fixed pay basis by the BTC, either grade 3 or grade 4, also need to apply. Candidates stroke applicants who are in BTC Secretariat office on fixed pay basis, either on grade 3, grade 4 may also apply, as there is no sanctioned post in BTC Secretariat office at present. So by this advertisement, all those persons who were on fixed pay, they were also directed to apply because there was no sanctioned post. Now by this
advertisement, they are willing to, why I'm pointing out this, by this advertisement, they are willing to fill up the sanction vacant post in the BTC. And the incumbents who were on fixed pay, they were also asked to apply. Now, page 33 is the call letter of the husband of the petitioner for written examination. To Sri Manik Chandra Roy, call letter for written examination, junior assistant, roll number is JRA 2285. He cleared the written examination. Page 34 is the call letter for interview. The interview of the petitioner's husband had occurred on 12/7/2009. The roll number is in between 2096 to 2427. Thereafter, my lord, the list of approved list of selected candidate that was published, that you'll also will find page 35. This is the type copy. And name of the petitioner was at serial number 106, that you'll also will find page 36. Manik Chandra Roy.
Yes.
Then page 39 is the order by which he was appointed. Although it was in pursuance to a regular selection process, interview, written examination, they have issued this order appointing him in fixed pay. In pursuance to the letter number so-and-so, dated so-and-so, the following persons are hereby appointed as junior assistant stroke LDA on fixed pay at the rate of rupees 5,200 only per month with effect from the date of joining of duty. The appointed persons shall submit medical fitness certificate from Joint Director Health Service of the district concerned. The candidate shall join in the place of posting immediately. Now, petitioner's husband name at serial number 28, page 42.
Yes. So in the advertisement, no pay scale was indicated.
No pay scale was indicated. It only says vacant post, and the other clause says that the persons who are on fixed pay can also apply in the sanction post. Now, appointment letter, page 43 is the type copy.
Page
43. February 28, 2011. On the same day, the joining was there. Page 45.
What is page 46?
Page 46 is dated 17 July 2018. By this, my lord, what they have done, they have, what it says, my lord. With reference to the subject cited above, I am directed to state that BTC is pleased to approve appointment of following 7 numbers fixed pay employees of entrusted department of BTC in the vacant sanction post as indicated below under the Water Resource Department in Kokrajhar, Baksa district as per the decision of the Executive Council meeting of BTC held on so and so. Now, by this, they say that the 7 fixed pay employees, they are appointed in a sanctioned vacant post. And name of the petitioner's husband, page 47, my lord. Manik Chandra Roy, junior assistant. He was placed at Executive Engineer, Baksa, Water Resource Division, Mosalpur. Earlier, it was Joint Commissioner of Transport, Kokrajhar. Now, thereafter, page 48 order was passed, granting him pay scale. In pursuance to Additional Principal Secretary, Borderline Territorial Council, Kokrajhar, so and so, for filling of the post subject to discharge without notice and without assigning any reason thereof, and subject to satisfactory police verification report, the following fixed pay employees are hereby appointed as section assistant against the vacant post in pay structure 14,000 to 49,000 plus grade pay 5,600 per month plus other allowances admissible under government rules from the date of joining under the establishment of Baksa Water Resource Division. Now, serial number 1 is the petitioner's husband, and post sanction and creation date is extreme right hand side, Miller, 21/9/1987. Then page 49 is the identity card. Then finally, page 52 is the death certificate. 7/12/2018, he died.
Yes.
Page 53 is the next of kin certificate, wherein the name of the petitioner and 2 minor daughters that they occurred. Then 54 is the scheme, page 54, that I have already taken your lordships.
Mm, 54, I've seen already 54,
Yes,
55. Yes.
lordships need not see again. Page 59 is the representation submitted by the petitioner for release of compassionate benefits. '59, '60, and '61. These are 3 representations submitted. Then they released 2 amount. You'll also will find page 63. This is for group insurance scheme, 2 lakh rupees. GIS money, this was released. Then, my lord, they released unutilized earned leave money, page 64. 7121. Then there is one communication at page 65. This was written by the executive engineer, Baksa Water Resource Division, to the principal secretary, BTC. Now it says, with reference to the subject cited above, I have the honor to state that Manik Chandra Roy, ex-section assistant of Baksa Water Resource Division, Musalpur, who expired on so-and-so after rendering service with effect from 26/7/2018 to 7/12/2018, that is 4 months, 12 days. He appointed as section assistant right office memo dated so-and-so, and additional chief engineer letter dated so-and-so after duly approved by the additional principal secretary BTC Kokrajar memo dated so-and-so. In this connection, it is to inform you that the Manik Chandra Roy, ex-section assistant, worked in fixed pay, rupees so-and-so per month as junior assistant in the office of Joint Commissioner of Transport BTC Kokrajar since 28/2/2011 till joining to Baksa Water Resource Division Musalpur white order dated 28/2/2011. Fixed pay is not pensionable service as per rule. Let Manik Chandra Roy, ex-section assistant, has no NPS during the short span of regular service period. Hence, no subscription was deducted from the salary for NPS. Only group insurance scheme at the rate of rupees 200 per month deducted with effect from so-and-so to so-and-so. Now an amount of rupees 2 lakh only being insurance fund under group C, and also an amount of rupees so-and-so only being encashment of unutilized earned leave salary for 10 days only have been sanctioned by office memo dated so-and-so respectively, and bill submitted by the treasury officer Musalpur for payment.
Reading from page 65.
65, madam. Then in the last paragraph, they say, in this context, it is to inform you that there is no provision for compassionate family pension scheme for those who expired before completion of 1 year of regular service. By notification dated so-and-so, clause 53, where in the circular stated that the government servant must complete 1 year continuous service without break before date while in service. I therefore request your honor kindly look into the matter and put valuable advice whether benefit may be allowed or not to so-and-so, wife of so-and-so, ex-section assistant, so that the undersigned may take further action. Now, scheme says 1 year continuous service. Now, this officer wrote to the principal secretary, his requirement is 1 year regular service. Now, page 66 is the impugn order. It says, as per instruction of senior FABTC Secretariat Kokrajar, the applicant do not come under compassionate family pension scheme as the late of ex-SA has not completed 1 year of complete service period. 1 year of complete service period. A person must complete minimum 1 year of service for CFP scheme. The CFP paid to all by all Assam recommendation of state government. Thereafter, there were thereafter another letter, that is page 67, dated 21/11/2020, by which the executive engineer again requested the chief engineer, water resource department, to look into the matter. Now, my contention is that, my lord, he in pursuance to a due selection process, he got appointment in the year, my lord, 2011. 11 to 18 he worked. So this period of service, this has to be counted as while calculating 1 year service. This period has.
This is the appointment of 2011.
2011 appointment.
Is it in page 43?
Page. Yes, my lord. This was the appointment order. So once he is given the regular pay scale, stroke regularized, then, my lord, this period has to be counted as qualifying service while calculating that 1 year service. Because the scheme says very specifically used word, continuous service without break. The requirement, it is quote unquote continuous service without break. My service was continuous and there was no break. Now the respondents, they in the impugn order interpreted, they want regular service. in my humble submission, Milord, there cannot be a different meaning. Because this is not a pension scheme. This is essentially a compassionate appointment scheme, purely.
Yes.
So this is not a pension scheme. This is essentially a compassionate appointment because this came in the year 2007 by Milord, earlier deleting the or abolishing the earlier policy of 2015 for giving compassionate appointment. And this is absolutely a beneficial scheme. I have the background of the scheme also. Under what? DC don't need job. Also, will kindly have a look. Perhaps this I have given this on the last occasion. Right? This was the budget speech of this under to have an idea of the background of the scheme, Milord, under what context the scheme was formulated. Yes, this is, Milord, one judgment I have given your lordships. This is the recent judgment of the Honorable Apex Court, wherein whether the contractual service will come under, although this is with regard to pension scheme, not with regard to the compassionate.
Which is the relevant para?
Facts, your lordship will find para 3 and relevant paragraph will be para 9.
Yes.
My humble submission, I'm sorry.
Yes. It is not of much use for you in this case.
It's
So
a,
your submission is
yes, my lord.
therefore,
Yes. Why I have
there is
placed,
nothing mentioned about regular service. 1 year of service has to
yes,
be regular, that's not mentioned.
nothing mentioned.
Secondly, going by the nature of recruitment,
Yes,
this is characteristics of a regular recruitment.
exactly.
And this is more fortified from the fact that persons working on fixed pay have also been asked to apply.
Yes,
So a fixed pay employee cannot be asked to be apply for another fixed pay job. So it
Exactly.
doesn't make any sense.
yes,
These are your two arguments.
Basically,
and
these
therefore
are
the 1 year period,
yes,
we'll have to take into account the.
yes. Why I place this judgment, my lord? Because the how the qualifying service will be calculated, Honorable Apex Court has given a hint that regularization is important. If he is regularized, if he is not regularized, fine, you don't need to calculate that or take into account that particular service. But once he is regularized, his past service in whatever form, it has to be accounted for ascertaining the qualifying service. That is the Milord, that is the reason why, Milord, I place the judgment.
But that
And-
is
and-
that is for regular pension.
Yes, regular
Yes, sir.
pensions. Yes, that is in the context of pension scheme. Now, here, Milord, since 2011, my husband was in government service.
All right, you have argued anything else to add?
No, nothing more, Milord.
Yes,
This-
Mr. Naik.
Lordship, coming first to the advertisement, Lordship.
No,
2, 3
first, would you please address this code that why this 1 year service should be treated as regular service? Service as a regular employee. Let us assume that he was not a regular employee for 1 year.
No, if
Why this interpretation is to be given?
Lordship, if Lordship comes to the scheme itself, Lordship,
Leave it.
page
All right,
54.
Page 54.
First, Lordship, may please come to paragraph 4, period number 4. In view of above, objective is above, Lordship. In view of above, it has been envisaged to replace the existing policy of appointments on compassionate ground of the dependents of state government employees. Lordship, may kindly see this, state government employees who die in harness by scheme for compassionate family pension in lieu of compassionate appointment. In short, called as compassionate family pension CFP scheme. Then again, if Lordship comes to 5.1, this is the definition under the pension rules of 1969. The applicable definition of family of the employee dies in harness will be the definition of family that is given in the Assam Services Pension Rules 1969. Next, Lordship, I am coming to 5.3, that is subpara. However, the government servant, 1 year is okay. But at the same time, he has to be a government employee. The government servant must complete minimum 1 year of continuous service without break before death while in service. So his service, his appointment, in fact, Lordship, in subsequent appointment, this is less than 1 year. That is what I'm submitting, Lordship.
No, but government servant is a defined expression here. Is government servant a defined expression under the scheme?
No.
Has it been defined?
In the scheme, it is not there.
Then
But
are you
general-
saying that he was not a government servant before his regularization?
Lordship, the regularization word is nowhere has been used, Lordship. It's a fresh appointment. His earlier appointment was as a junior administrative assistant. His subsequent appointment is the section assistant. If Lordship goes to the press Lordship appointment letter.
That's Mr. Naik. Please understand what is the key issue here. All these are irrelevant. The scheme says 1 year, the government servant should be in employment for 1 year prior to his death. Then he will be entitled to compassionate family pension.
Lordship.
Correct? Now, the claim of the petitioner has been turned down on the ground that he did not complete 1 year of government employment prior to his death. And that period was reckoned with effect from the date on which this
Fresh appointment was done.
fresh appointment was issued.
Lordship.
Now, what he is saying that why should the clock tick from this order? Why should the previous service not be taken into account?
Because the earlier service was not pensionable service.
Right. If that is correct, we'll accept it. But this scheme was introduced in 2017,
Yes,
right?
right. Lordship.
2005, the CPF came in. So from 2005 onwards, no government servant is getting pension.
No, it's from 2017, Lordship.
All right.
Lordship.
Pension is out now from 2005,
Yes,
right?
but that compassionate family pension
Listen,
was,
listen.
yes, yes.
You have to think very carefully because otherwise I'll record your submission. So you are saying that 1 year has to be pensionable service. Therefore, it has to be treated as regular appointment. So first of all, if this man was appointed 5 months prior to that particular date,
Yes,
then he would have been eligible according to you.
1 year.
But even then, he would not have got any pension because pension is no longer there.
But he would have been entitled for family pension.
Where is that?
This 1 year service, Lordship.
Family pension for 1 year service?
Yes, if Lordship comes to pension rules, 140 Lordship. Even for family pension, Lordship, the qualifying period is 1 year. This 1 year comes from the rules, Lordship.
Let us see.
140.
140?
Family pension start from 138, rule 138. That 1 year specification is at 140.
140, is it?
Yes, Lordship. Lordship, may kindly say. Except as otherwise provided in rule 142. Lordship, I am also going to read 142 because compassionate family pension was already there in the rule. But in the rule, Lordship, it was 50% and the qualifying service was 7 years. Now, by issuing this notification, it has been enhanced to 100% and the qualifying period has been decreased to 1 year period. 140, Lordship. Except as otherwise provided in Rule 142, a family pension not exceeding the rate mentioned in the Rule 141 will be admissible in case of death of an officer while in service or after retirement or on after 1st of January 1964, if at the time of death the retired officer was in receipt of a compensation, invalid, retiring, or superannuation. In case of death while in service, the government servant should have completed a minimum period of 1 year of service.
But that is pertaining to Assam Service Pension Rules of
Yes,
1969.
in terms of this rule, Lordship, even if the man himself is not entitled to pension, his wife would be entitled to family pension if he completes 1 year period. Now, if Lordship comes to 142,
Yes.
notwithstanding the provisions in rules 140 and 141 above, if a government servant after rendering minimum of 7 years continuous service dies while in service, the family of such government servant may be granted a pension at the rates and conditions mentioned below for a period of 7 years from the date following the date of death or till the date on which the officer would have reached the normal age of superannuation had he remained alive. Whichever period is shorter, the pension payable under this section will be at 50% of the basic pay last drawn, subject to a maximum of twice the pension
admissible under Rule 141 above. Next, 3 Lordship, Roman small 3. The provisions of this rule will not be applicable if the government servant had put in less than 7 years of continuous service prior to his death. So this scheme of compassionate family pension was there in the rule itself. But here the period was 7 years and the amount was 50%. But now under the scheme, Lordship, it is 100% and the qualifying period is 1 year.
Correct. But where is it mentioned that it is 1 year of regular service?
This rule applies only to the regular government servants, Lordship. But as pension rule 1969 is
There was
concerned.
some reference to the scheme that it will be governed by the provisions of the Assam Service Pension Rule.
Not specifically mentioned, Lordship, but if it is taken, if it is seen as in isolation of the rule, Lordship, in that situation, it will require us to pay him 2 pensions, Lordship, one under the rule, one under the scheme.
No, absolutely no. This scheme says is very clear. If the person is entitled to compassionate family pension, he will get fresh full pension till the date on which the deceased government servant would have retired.
Lordship.
After his retirement, then his or her entitlement will be calculated
Normal
as per
family
the
pension.
normal pension rule.
Yes.
So if the petitioner is entitled to receive that under the pension rules of 1969, then she will get it. Otherwise, she will not get it. But the compassionate family pension is meant only till the date of his retirement, had he been alive. So 1969 rules will kick in with effect from the date of retirement of the deceased government servant, not before that.
Yes.
Before that, only the scheme.
But in respect of the present case, Lordship, she is not entitled to normal family pension also.
That's not required. If she is not entitled to, don't pay her.
No, if she is not entitled to normal family pension, she is not at all entitled to
Show
compassionate
that
family pension.
rider in your scheme and I'll accept it. Where is it written that if she is not entitled to normal family pension, she will not be entitled to
No,
compassionate?
that in the scheme that has not been mentioned, Lordship. But it's only an extension of the rule, Lordship.
Anything else?
Lordship, 2, 3 judgment, Lordship, I'd like to place. Lordship, first one judgment, Lordship. Lordship,
Mr.
one is
Nayak hit the nail in the head. You have come up with a very serious pen. Come up with something which is concrete. These arguments will not help. Because you are arguments.
I think, Lordship, I would be able to explain my stand, Lordship, by placing this judgment, Lordship.
Please. Normal pension, all arguments will be ignored.
Lordship.
You have to show that this scheme, the claim of the petitioner will be completely governed by this scheme. If the scheme says this provision of the 1969 rules will apply, it will apply. If it doesn't say, it will not apply. So no question of relying on judgments of 1969 rules or any other rule.
Lordship.
Unless you first show that the scheme says that rule, provision of that rule will be relevant for this purpose. Then I will accept.
My only humble submission would be if that proposition is to be accepted, Lordship, once this retirement age is over, we have to pay her normal family pension.
You need not. You are not looking at the scheme. Look at the scheme. You need not. Let us see the scheme once again.
There are 5.3.
5.3.
Para 5.3. Page 50.
Yes, 5.3 is clear. Your argument stands belied by 5.3 itself. Where, please read it, Mr. Nayak.
Lordship, where the employee dies before superannuation, the family pension equal to 100% of the last pay drawn by the deceased employee be paid for a period up to the date of deemed superannuation of the deceased employee, that is the date on which the employee would have superannuated had he been alive. This would compensate the loss of family income to a large extent and fulfill the requirement of compassionate conditions arising out of the death of the serving employee. If Lordship comes to 5.9. 5.9.
Yes.
This will be applicable to all employees of state government, provincialized employees, and all others as eligible under Assam Service Pension Rules 1969. All state government employees under NPS category and all India service officers born on Assam cadre. So this scheme applies only to those, Lordship.
All right, anything else?
So this is my submission, Lordship. This scheme applies only to those in whose case this pension rule 1969 applies.
So in his case, NPS applies. After his appointment, NPS applies in her case.
In that situation, Lordship, for the period prior to his fresh appointment, Lordship, for that period, no contribution was made either by the state government or by the petitioner.
All right.
Paragraph 39, Lordship, 2008-15 SCC 380. 38 or 13 likha ase.
Paragraph 39.
Lordship. Page 394. The contention that the family of an employee would be entitled to the benefit of family pension in the case of death of a government employee if he had completed a minimum period of 1 year's continuous service without break cannot be accepted as stated herein before. An employee must be a government employee at the first instance. He must be working in a pensionable scheme. He only in that capacity should have completed a minimum period of 1 year of continuous service without break, which would mean that he must be in a temporary or permanent employee. So this is the nature of that 1 year service period, Lordship.
But this is pertaining to some
This is
rules, I
pertaining to
believe.
family pension, Lordship.
Family pension rules.
You will never regularize.
All right, for a moment, let us leave it at that. What was the purpose of the advertisement?
Lordship. If Lordship comes to the advertisement at page 29.
You say these are vacant posts.
Yes, but it is not mentioned whether these posts are sanctioned posts or temporary
So
posts.
what is it according to
Lordship, Lordship, first paragraph your Lordship has read, for recruitment and filling up of the vacant post lying in the council, that is secretariat, head of department, office, district, and subdivisional offices. If Lordship comes to a next page, H. Candidates who are already engaged to the office of the CHD district subdivisional officer on fixed pay basis by the BTC, either grade 3 or grade 4, also need to apply. Next I, candidates applicants who are in BTC secretariat means council, Lordship, office on fixed pay basis, either on grade 3 or grade 4 may also apply, as there is no sanction post in the BTC secretariat office at present. So advertisement was issued for the post in the secretariat also. First page, Lordship.
No, first of all, please come to page 29.
Lordship.
This is for filling up how many posts?
No mention.
That means it is one vacant post. The vacant post.
Yes, filling up of the vacant post.
So vacant post means it has to be a sanctioned post. Post means post, which is sanctioned. There can't be a post which is not sanctioned.
In my understanding, post may be a temporary post also. for today's context, Lordship, after coming into effect of the FRBM Act, Lordship, even for fixed pay posts, we need to create posts. Even for workers, we need to create posts.
But this is of 2008.
2008,
That
subsequent
time it was
FRBM.
not applicable.
This is subsequent FRBM, Lordship, 2005.
That's correct. So when the advertisement was issued, 2008, the FRBM you are talking about was not in force.
In force, Lordship. It came into effect in 2005. This is 2008.
So it is a temporary post.
Lordship, that is not mentioned. That is why I'm coming to the appointment letter, Lordship. In the advertisement, it has nowhere it has been mentioned whether it is a sanction post or temporary post or whatever is the nature, Lordship. But coming to the appointment letter, Lordship,
Yes. 28th February 2011.
11. Lordship, may kindly see here, in pursuance of letter number so and so, the following persons are hereby appointed as junior assistant LDA on fixed pay at rupees 5,200 / rupees 5,000. 5,200 and 5,000 only per month with effect from the date of their joining. So if it is, even if it is not mentioned there in the advertisement, from the recruitment, Lordship, from the appointment letter, Lordship, it specifies it's a fixed pay post.
Is there any is government servant a defined expression under any rules? Where?
Discipline appeal, madam. Assam Service Discipline Appeal Board.
It is not even defined in the pension rules.
It is there, Lordship.
In pension rule, not clearly defined. Like the Lordship. Rule 2E in the
As per this definition, even the services of people temporarily placed in the disposal will also be treated as government servant.
It is a fixed pay, Lordship.
Fixed pay or, so you show me something which says, is it a temporary post or what is it? You are changing your stand. The moment the court confronts you with one suggestion,
That
you
is
shift
a,
your
Lordship,
stand.
from the advertisement, Lordship, it cannot be ascertained whether it is sanction post, whether it is a temporary post, whether it is a fixed pay post or whatever, Lordship. But from the appointment letter, Lordship, it appears it's a fixed pay post.
All right, so fixed pay is a temporary measure. It will be a temporary measure. Anything which is not permanent is a temporary measure. So your section 2.
In this context, Lordship, I would like to please not rely actually. I would like to show one letter, Lordship, page 44.
You so, Mr. Nayak, see one question. This entire scheme is a beneficial scheme. It is a scheme which is away from the normal rules of pension, which is framed to give immediate relief to the families of the deceased person.
Yes, sir.
So the courts will always come with a positive, beneficial interpretation of this scheme. You have to show me something which categorically bars. Otherwise, we'll allow the writ petition. Because the court cannot interpret in a negative manner, bring that. So therefore,
yes, Lordship.
Does not include
Just one page, Lordship, at 44, Lordship.
Page 44, yes.
This is his appointment letter, Lordship. Lordship, may I kindly see the signature even not there. Lordship, we do not have any access to documents. These are not part of records. It is it is instructed me, Lordship.
No, but are you disowning these documents?
Not now, Lordship. Now there is no question of disowning this, Lordship.
And then
already man has expired, Lordship. But that is the issue, Lordship. Second, now if Lordship comes to the prayer, Lordship, On one hand,
But
he's
first tell me, have you understood the query of the court?
lordship.
I'm giving you a framework. Because I understand it may not be a very simple work for you, but you have to understand the framework in which the court is viewing the whole thing. Otherwise, going here and there, these are financial matters. We would be very careful
Lordship.
to adopt an interpretation. But at the same time, the court is also conscious that this is a beneficial piece of scheme
Yes.
formulated by the state to
Lordship,
give
in-
relief.
In fact,
So
Lordship.
we will not take a truncated approach of this scheme.
Yes, Lord. In fact, this scheme, Lordship, is an exception to the rules, Lordship.
Exactly. Therefore, by
So
referring to the
That is
rules,
that
we'll
is
not
why,
interpret.
Lordship, I am submitting. If it is an exception
That
to
is
the
why
rules,
you're saying
Lordship, the
by referring to
conditions.
1969 rule will not interpret anything in this scheme.
That is why, Lordship, that will give rise to another line of argument, Lordship. If it is an exception to the rules, Lordship, whatever condition has been given, there, Lordship,
Because we'll say
that has to be strictly compliant.
if the scheme was not there, she would not have got it,
Yes.
right?
Yes.
So the scheme tends to cut across the formula or the mechanism envisaged by the 1969, whatever this pension
No,
rules
that is my understanding, Lordship. If this scheme would not have been there,
Now, having done that,
yes.
now we are not going to get back to the 1963 pension rules to interpret the scheme so to deny her the right. Understand this for a minute. You want 24 hours time to reflect. The court does not have any problem. But please understand the query. We want a clear response from the government. Otherwise, we'll deliver our judgments. But that's not the idea. Idea is, as we said, we are conscious that it will have a financial implication. But that doesn't mean we'll not grant relief. Whatever strictly law, when it is applied, whatever is the outcome will happen. I'm repeating once again, you please listen to this with an open mind. Forget what you have prepared and come. If you get stuck up into that, then things will not proceed further. And I'm not asking you to concede on anything. But at the moment, it appears that you are not being able to appreciate the point where the matter is stuck up. See, this person's husband was in employment, if not permanent, at least temporary employment, which you are not disowning. That was with effect from February 2011. That recruitment happened pursuant to an advertisement regular selection process. Correct. So it is a regular, it has the trappings of a regular selection for sanctioned vacant post. The advertisement says vacant post. So we cannot interpret it as a not vacant post. That is not possible. After that, for some reason, he has been put on fixed pay. Why that has been done, we don't know. But here we are not on the question of whether he was entitled to 5,000 or 9,000 as salary. The question is, in the light of that proviso to 5.3, whether 1 year of counted from the date of the subsequent July 2018 notification or 2011. That is the only question here, nothing else. Now, to give a restricted meaning to 1 year, you have to rely on the pension rules. Correct?
Yes.
But she is not going to get the benefit because of the pension rules. But despite the pension rules not supporting her case, under pension rules, she doesn't get anything. So this scheme is an antithesis to the pension rule. It is not supportive. Scheme is a detour from the pension rules.
Yes, Lord.
It gives a benefit to certain class of family members of the government servant who are otherwise not entitled to pension. What is that benefit? The last drawn salary with effect from the date of death till the date of deemed retirement. That is first phase. After deemed retirement, in a particular case, the family may be entitled to pension, may not be entitled to pension. In this case, in all probability, she will not be entitled to pension. But it is not the claim of pension. Pension rules will come into effect, will kick in with effect from the date of deemed retirement of the employee, not before that. Before that, it will be the scheme. Scheme says 1 year. So if by one interpretation or other, he can show that her husband was in employment, whether permanent, temporary, for more than 1 year, matter is over. We are not going to go here and there to restrict that interpretation and bring that 1 year into 6 months by looking at statutes which are not connected with this matter. Just because pension word is used, that doesn't mean pension rule and compassionate pension scheme are in sync with each other. It is the opposite direction there.
Lordship.
Pension rules will not give her what she will get under the compassionate pension scheme. So there is no question of interpreting the scheme by relying on the provisions of the rules. Those are both going on different directions. Unless you show us something in the scheme which clearly defines what is 1 year, a restrictive interpretation will not be possible because it is a beneficial piece of legislation. I followed the point.
Yes, Lordship.
Now, having understood the point, you are free to argue. If you want, I can even give you time till tomorrow to reflect on this. If you want.
Not tomorrow,
Otherwise,
Lordship. I would like to
no,
pray for
beyond
some
that
time
will
because,
not.
Lordship, I would like to go through the notes,
Beyond that
Lordship.
will
Office notes, Lordship.
It will be difficult.
The objectives will be clear from the notes, Lordship. Objectives and the limitations, Lordship, will be clear from the, rules and notes.
Day after tomorrow, beyond that I can't.
Lordship.
Up to day after tomorrow, I'll give you time because it's a serious matter. And I do appreciate that as the state's council and the finance department, you deserve opportunity to rebut. But you will not be able to rebut unless you understand what is the issue before the court. Going here and there will not do. You have to show from the scheme itself that 1 year means 1 year of regular service. And you have to show that this appointment does not have the trappings of a service within the meaning of proviso to Rule 5.3. You succeed in both, the petition will be dismissed. Otherwise, allowed. And allowed with the date from the date on which he died. Till the date of his deemed retirement, you have to pay the pension. Area pension with interest.
Opportunity, Lord.
That opportunity will give you.
Lord.
You are entitled to. But don't drag it too far.
Lordship.
I don't want to, when a matter is heard, delivering early judgment is always
Understood.
what this court wants.
Day after tomorrow, Lord.
In fact, I would have dictated the judgment today itself.
Lordship.
CAV means same day. Judgment same day.
Yes.
Otherwise, what is the point? Beyond 7 days, I am not comfortable with keeping judgments pending.
It never happened also, perhaps.
that's
In
okay,
larger
but-
matters, it's different.
But
now-
Mr. Nayak, I hope you are clear about it.
Yes, Lordship, understood.
Leave no stone unturned because this court is still open,
Lordship.
but it will be closed on Friday. Heard so and so.
I don't want to trouble my brother.
Yes.
Friday, I may remain out of station, my lord. My colleagues will be there, or any Monday, my lord, if not inconvenient to. Or Thursday, I'm here, my lord. But my friend has some.
Thursday, what is the point in giving 24 hours? He needs time to. All
Yes.
right, we'll have it Monday at as fixed pattern matter. Fixed pattern matter on Monday.
Right,
Mr. Nayak ko naam to likhi. All right.
Lordship.
Who else is appearing? Mr. Talabia. Yes. What do you have to say? You are shaking your head like this, and now you don't say anything. All right. All right, then Monday.
Fine.
Fixed pattern matter for hearing.